Made the Lord. My Lord, I beg to mention in item number 33, my Lord.
Huh?
I beg to mention item number 33.
Yes.
My Lord, may not like to take up the matter now. In item number 33. My Lord may not like to take up 33.
53.
No, my Lord. 33. 3.
Yes. Before any other.
I'm deeply aware.
May I please, Your Lordship. Lordship, with regard to item number 22, Your Lordship. Lordship, we have received the affidavit of opposition filed by the APDCL authorities day before yesterday, Your Lordship. I'd like to file a reply upon that, Lordship. If necessary, Your Lordship. Reply is necessary. And part we have to take instruction from our clients also, Lordship. We have to communicate the affidavit to our clients also, Lordship.
The learned counsel appearing on behalf of the petitioner seeks for an accommodation of 4 weeks for filing a reply. So list the matter.
Lordship, I have a humble submission, Lordship. There is an interim, Lordship. Till today, it is there, Lordship.
What is the matter then?
Lordship, it's regarding electricity, Your Lordship. Means like without any following the due procedure, Lordship, my electricity meter has been changed, and upon suddenly, Lordship, a very high rate has been imposed upon me. And upon that, Lordship, I have paid 50% of that proposed rate. Also, I have paid as per the course order, Lordship.
This matter came up before me earlier.
Yes, Lordship, but Lordship did not hear the matter at a length, Your Lordship.
Remember, you have paid the total amount, whatever it is there. You say that you have paid some amount, and as such, on that basis, it has been stayed.
Yes, Lordship. Yes.
Some 1,35,000.
3 lakhs, Lordship. Something 3 lakhs, Lordship. Once I paid before the authority, before filing writ petition.
At the time of filing an appeal, you have paid 50%.
Yes, Lordship. Yes, yes.
And then?
Correct, Lord. Lordship, then after, as per the court order, I paid another 3 lakhs, Your Lordship.
How much is the total?
Lordship, total would be
From 30 lakhs?
total will be among like I'm not.
We'll pick up the matter.
Yes, yes, Lord, we will pick up.
Can I please?
Much of that.
With the concern of the other side, I beg to mention item number 17 and 31 here.
17,
And 31.
17 and 31.
Lordship, may I
Yes.
kindly take up the matter of the 2 weeks?
Hmm?
Senior is in bereavement, Your Lord. Learned counsel and Samuel Cook's mother has expired. Your Lord. Day before yesterday.
Who is in bereavement?
MS ML Gop. MS ML Gop here.
Huh?
MS ML Gop. ML Gop here.
But was in this matter, who was appearing?
And Haveli, Your Lord.
Then where is
She
she?
is also not. She is also out of station, Your Lord. With senior ML.
In one of these matters, I have asked you to file an additional affidavit. Have you filed that affidavit? Then why should we not dismiss your petition? No adjournment. Because in these matters, Ms. Havelia was appearing.
Yes, sir.
Ms. Gop was not appearing. Then where is the question? And that too, when this court has specifically, there is a stay order operating in your favor on the basis of, because the GST authorities have categorically stated there is, you have not filed it. And an order was passed by Justice Koteso saying that till the disposal of that representation, the amount cannot be imposed upon you. There was a stay. So under such circumstances, this court had directed you to produce. On that day, you have produced it and said that you have deposited, you had filed it on 22/2/2021.
Here are 2 to 20.
And thereupon, Mr. Kyles opposed the same.
Yes.
And as such, I have directed you to file the affidavit. Then why haven't you filed the affidavit?
Since then,
No adjournment.
item number is 20. Kindly pass up the matter for the same.
Item number
20.
20.
26.
26. At the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Item number 34, Lordship.
Hmm.
I'm for the petitioner. I want to withdraw this with on instruction. On instruction, I want to withdraw this.
Mr. P. Sharma, appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal.
Complex.
May I take that? My lord, the one IA hearing file, my lord, which is listed as item number 56, my lord.
56.
My lord, for withdrawal of the review petition. Yes, my lord, direction passed in the review petition has already been complied with. Direction issued in repetition has already been complied with.
So you want to withdraw?
Withdraw with the review.
The learned counsel, appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant application. We'll take up this matter because here is a direction, there was a direction to comply within 60 days.
F2, my lord.
At
F2, my lord.
two. Yes.
Victim is item number 41. When I be taken after 4 weeks, my lord, I need to file a pleading petition on the new incumbent, but in the meantime, my lord, the petitioner is not keeping good health. He's an elderly person, 79 years old. So he is not keeping good health. I cannot file the pleading petition.
Who is not in good health?
The petitioner
Okay.
after 4 weeks.
The request of the learned counsel for the petitioner, matter stands adjourned for. Matter stands adjourned to be listed on 4th of October. The affidavit be filed by then.
But in pleading petition, in pleading petition.
Somebody died.
No, my lord. In pleading petition, it says the first
Some other
new
persons.
incumbent should have to be in.
The learned counsel for the petitioner submits that seeking compliance of the order, the instant contempt application was filed. However, till date, the same had not been complied with. The earlier incumbent had also in the earlier, there is presently a new incumbent to the said post. And as such, he would like to take steps in that regard. This is the matter of the 6 weeks.
Okay, item number 25 of daily corporate.
Hmm?
Kindly, 25,
25.
Of-
Yes.
may kindly be adjourned for the day. My senior's mother's health is not well. He is in serious condition, so he had to leave for his home this morning.
You want an adjournment? Item number 25 to be listed after 4 weeks.
Had you obliged?
May please, Your Lord. Item number 1, day before yesterday evening, they filed a additional affidavit. And today we are filing our reply, my lord. I pray that the reply may be brought on record. Let us be taken after some time till the affidavit comes.
You have a copy of the reply?
Well, it's being prepared.
You have a copy of the reply?
Right now it's being prepared.
You have not filed, that means.
It's being filed.
You have a copy of the reply with you.
Right now I don't have.
How do you say that it has been filed?
No, I'm saying it's being filed, man. It's being,
You are saying that there is a copy of the reply.
their additional affidavit they have filed. We have,
Let's see, I have called for the registry to submit a report in my order. Let's see what has come.
My lord, I have also filed similar matter, madam. An additional affidavit was filed, ma'am. If I may file a requisition for calling of the applicant.
That has not been brought.
But I can check the file, madam. It told me, because on 20th it was filed.
Let's
believe
see
that-
when the item is called. We'll see.
Otherwise, I have a copy of it.
Item number 1.
That's it. Okay. Where the problem is fine, but still kept. Hold on.
Yes. Additional affidavit has not come on record.
My lord, I have a certified copy which we have filed. So what happened during this time? It's very important aspect. They have filed one affidavit, additional affidavit last time, last day, annexing one particular document, which is their submission that was the copy of the
Enclosure.
enclosure of that particular document. Now we have filed the certified copy of the entire record. Along with the now already though there is a stay order, but in spite of the stay order, they have proceeded and the charge sheet has been filed. But there is an inquiry was going on against the delinquent IO by the magistrate. Why you have, because that was intimated to the IO that there is a stay order. In spite of they have continued with the investigation. So there is an order that can go to it also. And he was subsequently exonerated from that, but the charge sheet was pending. Now we have collected the entire charge sheet, all documents from the record, from the court, the certified copy. That document does not exist nowhere. That document, because
You
First-
have filed an additional affidavit.
yes, that
bringing-
is coming. Yes, that's right.
Will the,
Otherwise,
no, the additional affidavit is also not on record.
Yes.
So we will take it up on another day, on
Yes.
day 30. We'll take it up on 7th.
yes. So that is why, my lord. and
On
not-
7th, let us take it up.
Yes, that is why, my lord. The reason is we have not got the certified copy earlier position, my lord, because it was not seen by the magistrate. Because it has to be marked as seen. If there is an additional document along with the charge sheet, the rule is that the CGM or the concerned court has to mark as a seen. Only then we are supposed to get that particular certified copy. That's the rule. Now, what has happened in this case? They have filed it through online.
There's a e-filing process.
E-filing procedure. Generally, when e-filing is when the person is somewhere else, he can't go to the police station. These are for that purpose, he has filed it, the e-filing. And the e-filing is supposed to write the gist of his allegation, which has been taken down in this particular case. His gist, that is admitted by them also. But there is no annexure. Though there is in the endorsement, there is an annexure, but nowhere, even in the charge sheet, there is no mention about that particular annexure. That annexure neither exists. Whatever document they have on the last occasion they have filed it, that was not seen, not in the record. And the lordship can see that's not on record.
We'll have it on 7th.
Okay.
Mr. S. Bhottaku, the learned counsel appearing on behalf of the respondent number 4, submits that an affidavit has been filed. The additional affidavit has been filed. Day is 29, no? On 28. On 28/8/2023. Mr. A. Bora, the learned senior counsel appearing on behalf of the petitioner, further submits that an additional, that the reply has also been filed to the said additional affidavit today. So list the matter again on 7th of September for further consideration. The registry shall bring on record the said affidavits. Number 2,
Senior counsel is another court take panty password for type.
Yes, we have received.
बाकी जाए proceedings.
Yes.
देखो ना, ना. So the Bakizai case is there. There's
Yes.
no quarrel with that. So only thing is that the respondent was not representing. So you take substituted service and proceed. That is what he wants. That's all. The instant writ petition was filed by the petitioner seeking a direction upon the Deputy Commissioner Dipu, Karbi Anglong, to trace out the case records of Bakizai case number 103/2008 and to dispose of the same in accordance with law. Full stop. Ms. S. Purva, the learned counsel appearing on behalf of the Deputy Commissioner Karbi Anglong submits that the records of Bakizai case number 103/2008 is available in the Bakizai branch of the Bakizai branch of the District Commissioner Office of Karbi Anglong. He further the learned counsel for the respondent further submitted that it was on account of the service could not be affected upon the respondent, number 2, that the Bakizai proceedings could not be proceeded with. Full stop. This court, by an order dated 9/8/2023, sought for instructions as to whether the Bakizai proceedings could be proceeded by affecting service in affecting service through substituted mode as permissible under the Code of Civil Procedure 1908. Ms. S. Borua today, the learned counsel appearing on behalf of the Deputy Commissioner, District Commissioner Karbi Anglong, submits that in terms with the provisions of the Bengal Public Demand Recovery Act 1930, substituted service as mentioned in Order 5, Rule 10/20 of the Code of Civil Procedure is permissible. Accordingly, the said instruction is kept on record and marked with the letter X. Accordingly, this court disposes of the instant writ petition with a direction to the District Commissioner Karbi Anglong to proceed with the Bakizai case number 103/2008 through the Bakizai officer and take such steps as is required for bringing the said Bakizai proceedings to a logical conclusion. With the above, the instant petition stands. And what say? Yes, Mr. Sikdar, what are you asking?
My lord, at this stage, my lord, the petitioner may be given a liberty to appeal before the authority, my lord. There is a provision of statutory provision of appeal under section 9 of the Assam Unauthorized Eviction Act 1970. My lord, the school was established in 1954. Well, at that time there was no railway office, but now they want to evict this building.
Yes, Mr. Who is there? Railways?
I'm appearing on behalf of Dr. B.N. Gogoi. My senior is out of station due to NCLT matter, urgent care case. My senior is out of station due to urgent matter of NCLT case.
Oh,
I'm appearing on behalf of Dr. B.N.
urgent matter for?
NCLT case. Lordship.
Mr. B. Sharma, kindly come here.
Well.
You are not authorized. You are a railway council?
No, Lordship.
Not necessary. Mr. B. Sharma, this is a notice under section 5.
5 of the
The order has been passed under section 5 of the public premises. This court have all along stated. The question of this court exercising jurisdiction does not arise. He wants to file an appeal under 12. 12, na?
Nine.
I give him 12 days time from today of approaching the whoever it is, the appellate court. And till this 12 days, the interim order shall continue. Thereafter, it will be for the. The instant petition has been filed by the petitioner. Challenging the order dated
My lord, it's 13.
13/5/2016, passed under section 5 of the Public Premises bracket Eviction of Unauthorized Occupants Act 1971. It reveals from the records that on 16/3/2015, a notice was issued under section 4 of the Act of 1971 by the estate officer NF Railway Lambding, thereby asking the petitioner to show cause as to why he should not be evicted under the provisions of the said act. The petitioner accordingly submitted a reply stating inter alia that the petitioners have been petitioner.
Petitioner, my lord,
The
sorry, is-
petitioner school has been running for the last 50 years in the said land. However, from the perusal of the said reply, it does not reflect that there was a denial that the land is not railway land. Be that as it may, an order was passed on the section 5 of the Act of 1971, dated 13/5/2016. Whereby it was held that the petitioner school was in unauthorized occupation of railway land, and thereby directing the petitioner school to vacate within 30 days from the date of publication of the said order. It appears thereupon that the petitioner filed the instant writ petition on 10th of August 2016. This court, by an order dated 17/8/2016, taking into account the submissions made by the petitioner that the land wherein the school is situated is a government land and not a railway plot of land. At state, the order dated 13/5/2016 passed by the estate officer until further orders. It further reveals from the records that an affidavit in opposition was filed by the respondent authorities, wherein it was stated that the school has been established on railway land, which is clear from the certified land plan number L/6/54/63, jointly signed by the Railway Authority and the State Civil Authority, for which the school of the petitioner is liable to be evicted as per the provisions of the Act of 1971. It was further mentioned in the said affidavit in opposition that as the school building was constructed illegally by trespassing upon the railway land, the petitioner school has no right to remain in unauthorized occupation of railway land. It was further mentioned that it being an admitted fact that the school building is situated 235 feet away from the railway line, but as the railway line extends up to 300 feet from the railway line, which is ascertained from the certified plan, the case of the petitioner that the school of the petitioner stands on railway land, on government land, is baseless. Upon hearing the learned, this court have duly heard the learned counsels for the parties. The question which arises for consideration is as to whether the land upon which the school stands is a government land or railway land. These are disputed questions of facts, and the fact-finding authority have already ascertained the same. The learned counsel for the petitioner at this stage, therefore, during the course of the arguments, therefore, submitted that as the disputed questions of facts are involved, the petitioner may be given an opportunity to avail the remedy under Section 9 of the Act of 1971 before the learned district judge. District judge where?
My lord, it will be,
Jose?
no, Lamding, my lord.
Lamding will be?
My lord, it will be, my lord,
Either Hoja or Nogam.
Karbi Anglon, my lord.
Either Hoja or Nogam.
Karbi Anglong?
No,
No. It would depend upon the area, my lord. Either
my
Nogam or
lord,
Hoja.
it is, my lord, fully situated within the Lamding, so my lord, it will be an Dipu, I think.
Huh?
It will be
Difu.
Dipu. Full address to it.
It is in Lamding.
Singh MT DC Colony Dipu.
Difu. Before the learned district judge Difu, which is the appellate authority. This court, upon taking into consideration that there are disputed questions of facts which cannot be entertained by way of the instant writ petition, grants the liberty to the petitioner to avail the remedy under Section 9 of the Act of 1971 before the learned District Judge, Karbi Anglong. Full stop. The liberty would be for a period of 12 days from the date of the instant order. Full stop. The interim order passed earlier shall only be would only be valid for a period of 12 days from today.
My lord, 12 days.
It is made clear that the above observations shall not affect the adjudication of the appeal by the learned district judge. If so, if any appeal is preferred by the petitioner. Yes, Mr.
My
Sikdar.
lord, 12 days will be very less. It will be
Mr.
at least
Mr.
3 weeks.
Sikdar, after I retire, I will contest election. Then I will go to the parliament, change the limitation. It is 12 days. That is why.
My lord, some more time. My
I
lord.
can't. This 12 days. From the date of the order is only 12 days. The period of limitation is 12 days. I can't. Why I didn't make it 13 or 15? Normally we gave 1 month. I can't give it. Can by way of an exercise of jurisdiction under 226, I can extend it? No.
People of it.
Enough for. Yes.
May I please? My lord, the requisition filed against the interim order dated 16/8/2007 passed by the special tribunal in special LG case number 2 between my page 70.
Shall not be issued by setting aside and quashing the order passed by the learned tribunal so and so whereby the case has been dismissed, holding as not maintainable. Reading the mature demand. Yes. So your case has been dismissed.
Yes, my lord.
Why you are filing a case under 226?
My lord,
It's an order by a tribunal.
my lord, there is no appellate tribunal.
So
So
227. How is 226 maintainable? Tell me. They are tenant.
yes, my lord, the response number 2 is the tenant of under.
How can you invoke land grabbing act? File a suit.
Yes,
Matter ends.
it's pending, my lord.
Huh?
Suit is pending.
Then what is this land grabbing business against the tenant?
Suit is pending, my lord.
Nothing. That is why nothing has happened. And you are happy for the last 5 years. The instant writ petition has been filed by the petitioner challenging the order dated 16/8/2017 passed by the learned land grabbing tribunal. Nagaon in special bracket LZ case number 2/2016. From a perusal of the materials on record, it transpires that the said proceedings, land grabbing proceedings under the provision of the Assam Land Grabbing Act. What is that? Act name?
Assam Land Grabbing Prohibition Act 2010.
Assam
Land Grabbing Prohibition Act 2010.
12. Act 12. Was initiated against the petitioner, against the respondents herein. Against the respondent number 2 and 3 herein, who are admittedly the tenants of the petitioner and against whom recovery eviction under the proceeding, under the Assam Urban Area Rent Control Act 1972 is and in proceedings under Assam Urban Area Rent Control Act 1972 have been also initiated by filing suits. Taking into account that the respondent number 2 and 3 are tenants, the possession so entered into the land cannot be said to be an illegal possession. Entry into the land, into the premises cannot be said to be an illegal possession. Full stop. Consequently, this court is of the opinion that the learned tribunal was justified in dismissing the said application. By the order dated 16/8/2017. Accordingly, the instant petition stands dismissed. Give your name.
Hi,
Yes, revenue,
Money paid. Money paid.
money paid.
Yes.
Money for what?
This is under SDRF scheme, my lord.
Eh?
Ex
4
gratia
lakh
grant.
for ex gratia compensation of that one.
Yes.
None appears on behalf of the petitioner. Mr. A. Vachaji, appearing on behalf of the revenue authorities, submits that the amount of rupees 4 lakhs have already been 4 lakhs
Yes, 4 lakhs.
have already been disbursed to the petitioner. Instruction is there?
Yes, I have. It is in favor of additional deputy commissioner.
Huh? In that regard, he has placed an instruction issued by the additional deputy commissioner,
No, no, no. This is
instruction. Issued by the deputy secretary to the government of Assam Revenue and Disaster Management Department. In the said instructions, from the said instructions, it revealed that the amount has already been paid, have already been released to the petitioner. Accordingly, nothing further survives in the petition. The said instruction is kept on record and marked with the letter X.
of like.
Because tomorrow they may say, I don't know, I have not received. Then
May
we
I
can
get a
say
copy of
that
this?
yes, the instruction.
May I retain a copy of this?
You have a copy, but that copy remaining.
Come on.
6.
Lord, in this matter, my lord, the file got misplaced in the office. My lord, the letter is there, my lord, it could not go out. If I may be granted 2 weeks' time, my lord, I'll ensure that it goes out, it gets. The file got misplaced.
As approach being aggrieved of the action of the in carrying out the construction over the land of the petition.
My lord, there was
This
some,
court made a specific query with the learned counsel appearing on behalf of the Deputy Commissioner South Salmara as regards any instruction to which she submits that she has no instructions.
yes, my lord, the letter couldn't go out from the office, my lord. The file got misplaced
Huh?
in the office. The file got misplaced in the office. I just got back the file. The letter is in the brief, my lord. It could not go out. I'll ensure that it goes out today. Lordship grants me 2 weeks' time.
Ms. S. Sharma, the learned counsel appearing on behalf of the Deputy Commissioner South Salmara, request for an accommodation of 2 weeks so that the instructions so sought for by the order dated 11/8/2023 could be obtained. Taking into account the above, list the matter again on September 13th.
Deeply obliged.
Full stop. It is made clear if no instructions are received this court would have no other, this court would have no other option but to call the deputy commissioner, seek the personal appearance of the deputy commissioner on such date as may be fixed in this plan. Water resource, where is the water? resource? Yes. Yes, why?
The direction can be issued in this case. my
Verify
lord.
and pay.
Yeah.
Dispose.
If not already paid, because petitioner is
That
not.
will be there. If not already paid, verify.
Obliged.
4 months. Take it on naam to nane pe. Yes, what remains?
My lord. Related to the-
Petitioners have done all that is possible in their command to hold the elections. Therefore, deem approval to continue until further orders.
My lord, we are trying to
Does anything remain? This order was passed in 2018.
My lord.
The tenure of a cooperative society under section 31 is 5 years.
Yeah.
5 years have gone by dint of an order passed by this court.
Fine.
What do you
Ten-
mean?
10 years, my lord.
And
They were
then-
10 years by one election.
10 years.
My lord,
Earlier we
In
are
fact,
5 years. No, when we are.
the
No,
board was,
by
election.
operation of section 39, if you don't hold the election, the matter finishes.
My
How
lord,
can you take anything?
my lord, we are trying to conduct the election, my lord. We are trying to conduct the election, my lord.
So?
But it is the, my lord, additional district magistrate, my lord, who impose the section 144 and hold the election, my lord. After that, after that, the deputy registrar also submit a representation before the deputy commissioner, my lord. Finally, deputy commissioner pass an order that as there is NRC process is going on, my lord, that's why the
As
NRC process at that time. NRC. As due to such, my lord.
so now what remains?
Lord, they allowed to
I-
conduct the election, my lord.
Huh?
Conduct the election, my lord.
No. I think better you withdraw, because if this court has to hold it, I will immediately ask the register, because your tenure is the end. And as such, the register will appoint the 41-6. And 41-6, they will appoint one-man committee. You want to hold it, that is your lookout. But this court can't extend anything. Only thing is withdrawal. Then whatever it takes.
2 days time may given, my.
Huh?
2 days time may given.
Okay, then we dismiss.
1 day time,
No, we may give till 2 o'clock.
my lord.
Withdraw, otherwise this court has no other option.
no, my lord, in case, except my lord saying that the departmental officer will hold the election under 41-6, there is no way out, my lord.
That
So
is
lordship
what,
may close it, my lord.
no, that is what.
Yes.
I have to say that.
Yes.
The moment I touch it. If you withdraw, then the question is different. That is the only way out. Otherwise, this court has no other option. But to exercise this, saying that period of 39 is over, there is nothing under 135. So this, because they also can't extend unless there is a pandemic. 2 o'clock.
May I plead your lordship? Lordship, I'm
Yeah.
paying for some accommodation.
Huh?
Paying for some accommodation. in
For
this
what? On the earlier occasion, you did not appear. Now accommodation. What is this
Some time
accommodation?
may be
This
done.
is under what?
My lord, the
Eviction.
eviction matter, my lord, section 4 notice is under challenge. This is basically become infructuous, my lord. And probably it is not maintainable also, my lord. Whether a challenge to section 4 notice is maintainable, that is the issue.
No way.
Public premises.
We have asked you to reply and you are challenging it here. And from
Lordship-
2018, you are getting an interim order.
Recently, my lord,
One has to give heads off to the railway. I think railway has a lot of land, so they are not in a position to do anything.
I've tried to
Like,
get a
the instant writ petition has been filed challenging a notice under section 4 of the public premises issued by the estate officer, NF Railway, Maligaon, under section 4 of the public premises bracket eviction of unauthorized occupants act 1971. Taking into account the provisions of the said act of 1971, whereby an authority and jurisdiction has been conferred upon the estate officer to take such steps for issuance of such notice, this court finds no reason to interfere with to exercise the writ jurisdiction under Article 2 to 6 of the Constitution. Accordingly, the writ petition stands dismissed. The interim order stands repeated. Then
Here is my lord, petitioner has a plot of land measuring 3 kathas of land. That was hired by the army authority way back 55 years back, in the year 63 or 64. And that particular land agreement was also not provided to the people. Now,
who is appearing for whom? Why you are making all these people a party?
but two
The land has been taken. The land belongs to whom? You.
Yes.
Yes, Mr. R.K. Dev Chaudhary. Why are you taking the land?
This case is handled by A. Gayan, CGSC.
Yes, ma'am. An accident.
Madam Anuradha Gayan, Advocate Anuradha Gayan, she is also the CGC. She is handling this case, madam, on behalf of the Union of India. And she has made a request to me, madam. Yesterday night, she has met with a car accident. So therefore, madam, she seeks an accommodation of 1 way.
For her, let us take the help of the affidavit in occupancy. Who is Nor Bahadur Shetty? Who is Nor Bahadur Shetty?
the father of the
So you entered into a lease. Your father entered into a lead with them
and that was expired
on
31st December 2012.
2012.
Thereafter, lease agreement has not been renewed.
So under such circumstances, as per their own stand, they are to take recourse to the provisions of law. Mr. R.K. Dev Chaudhary, whatever you do, we'll have it on 7th. And on that day, you get your instructions, whatever it is, because in your own affidavit, you have stated that if this period is over and no dehiring can be possible, then you'll be acquired. But how can you keep? Can you be a tenant or a tenant by insufferance? The military, can it be a tenant by sufferance? That is what they are trying to say.
Lordship, can it be on
7,
7th?
8. List the matter on 8. On which date? Mr. R.K. Dev Chaudhary, the learned Deputy Solicitor General of India, shall obtain the necessary instructions as to what course of action the respondent, the Respondent Union of India proposes to take in respect to the land of the petitioner, wherein the lease period have admittedly expired in the year 2000. 11.
We have filed a additional affidavit on 23/8. That's on record. Additional affidavit?
Yes.
In the affidavit, my lord, at page 39.
Huh?
Just 39.
What is this case?
This is regarding non-payment of contractual bill, my lord.
Contractual bills of 7,11,700.
700.
Then there is some affidavit filed by somebody saying that you are not entitled to.
That affidavit filed by the Revenue
Respondent number
Department.
6. What does it say?
Revenue Department, my lord.
We say that, my lord, no administrative approval was obtained, my lord, from the Revenue Department. And the Revenue Department has no knowledge, my lord, about this work.
I have annexed the administrative approval, my lord, at page 39. In the additional,
Page
at page 39.
of
Additional affidavit filed on 23rd of August this month.
to the chief engineer issued
Yes.
by the whom? Government of Assam. Under
Yes,
secretary to the
Under
government of Assam. That is it.
Yes, my lord.
Annexure A.
Annexure A.
This is by whom?
By
Administrative
Lord,
approval and
under
financial
secretary.
sanction of funds for construction of circle hospital.
See,
Assam.
PWD, my lord.
PWD. my lord. Actually, and thereafter, my lord, the communication, my lord, page 47, my lord.
Completion certificate has been given.
Yes, my lord.
Then why you are not paying it?
Page 46.
Circle officers quarters.
Yes, my
Is the circle officer staying out there? Mr. Borpujari, is the circle officer staying?
That instruction I do not
No.
have to obtain.
You can very well know by 2 o'clock if necessary. But the thing is, if they are staying on a land or house made by him, return him all the bricks.
He had a
No, you can't. You can't say that no, administrative. You are using this thing. You have asked them. There's an administrative approval from the PWD on the basis of which he has done the work. Then why you are not making the payment? The completion certificate has been given by the PWD.
No, my lord, the whole problem is arisen because the PWD has not filed any affidavit. The writ petition, my lord, I am submitting on the first day, my lord, the writ petition, my lord, allegations were made against the revenue. Now we have filed the affidavit, my lord, stating that, my lord, we have no knowledge. Now it is the PWD, my lord, let them controvert, my lord.
No, they don't controvert. That is on the last occasion. I have made it very clear. They have neither filed an affidavit, neither they care to be appearing in the matter.
Necessary direction.
My lord will just peruse the latest additional affidavit that my friend has.
And
Petitioner has,
page
my lord.
47, my lord.
Wait, let us see. Yes, what is this additional affidavit?
My lord,
Yes.
additional affidavit, my lord. If you go by the annexures, my lord, page 47.
Page?
Page 47, my lord, annexure D.
Ah.
My lord, this is a letter from the government that is in the PWD Building and National Highway Division, my lord. That is the government, from under secretary to the chief secretary, inviting, writing a letter that I am directly returned here with the demand proposal submitted by your letter reference such and such. A copy of the endorsement from Judicial Department and request you to take necessary actions for submission of demand proposal in the financial year 22-23. Meaning thereby, my lord, that PWD has moved for the proposal. The next page, my lord, page 45
Okay.
of 48, my lord.
that with reference to the subject, I am returning the demand proposal for with its enclosure original and you were requested to submit proposal for FS. FS proposal, financial sanction. So then the next page, my lord. Statement at still return saving amount for during. So my lord, let me, this is the latest position, my lord. Let me seek instructions on this additional affidavit, my lord.
No, today, Mr. Dhar, we could catch hold of you. Otherwise, it is very difficult to catch hold of 3 departments. One happens to be PWD. Very difficult. One is Union of India. Very difficult. You are a dearth of councils. There are many other councils, appoint them. And the revenue is on the side of you and the finance is on the side of you, they'll give the permissions. We don't have any lawyers. Every time the PWD matters come up, it is very difficult. Nowadays, for good reasons, the forest is appearing. Otherwise, earlier forest was also not appearing. When? Instructions.
My lord, will fix the matter on 10th. 10th, my lord.
10th Sunday.
Oh, sorry, my lord. I am going by the.
This is the matter on 11th on which date Mr. Ardhar, the learned counsel appearing on behalf of the PWD shall obtain the instructions and more particularly as regards the contents of the additional affidavit so filed by the petition. Well, yes, have you done this Ministry of Environment and Forest?
My lords, I have an instruction. My lord, this was never sent. Because my lord, there are some, this Povitora boundary is not final. There are some petitions pending regarding, my lord, I have instructions.
So if it has not been done,
Not
then
been done.
no,
So 10
no.
consent, my
Let
lord.
us, if it has not been done, how the deputy commissioner, because he is worried with the order of the deputy commissioner, how could the deputy commissioner presume? Because it was only a direction upon the Ministry of Environment and Forest to take it, to do the needful. That having not been done, how can that order be passed? Isn't that your case?
Exactly on the other side of another view of the matter, my lord. If it is not done, if it is not been sent, the 10 kilometers stands by Supreme Court order, my lord.
Huh?
By the virtue of Supreme Court's order, my lord, if it's not been sent, it's 10 kilometers. If lordship sees page 132 of the petition,
Let us see.
and also my instructions,
We'll see your instruction. Let us see
132,
page
madam.
132, 133.
132,
Why is 132? 133?
132 of the petition.
Yes.
The proposals for 21 national parks and wildlife sanctuaries in respect of which proposal have not been received by MOEF, my lord.
So
It's Povitora.
these proposals have not been received.
And
Now
in
see
that case,
what has been.
133, my lord. Page
Eh?
133.
That is what I'm saying. Under the circumstances, we direct that area of 10 kilometers around 21 national park and so be declared as so by the MOEF. There's a direction to the MOEF to declare.
My lord, I'm perfect. And a coordinated bench of this court, my lord, in another matter has held, my lord, since it has not been declared, 10 kilometers stands.
Huh?
10 kilometer.
Huh.
It by dint of this order, my lord, it has been it stands, my lord. MOEF has declared, and by the virtue of the Supreme Court order, some other subsequent developments are there, my lord. Some other orders have been also passed in one this writ petition, Godavarman, wherein it has been clarified, my lord, that when it is not proposal has not been received, 10 kilometers stands, my lord.
Where?
My lord.
Where is it? Show me that. Because from this I am not satisfied. Now don't come up with the fact that Godawaran from 1996 have passed many orders. And as such, I don't know which order.
MOEF is not meant. MOEF.
Huh?
No, my lord. Another view of the matter.
No,
my lord.
that
MOEF
is, I've been hearing from him.
Yes.
There is another, what is that Bhatgiri Park?
Bhatgila, my lord.
But the
That I have to concede, my lord, that
Yeah,
there is no order, my lord.
Yeah, that is from 2006 a matter is going on. Where he's been trying to find out. That day I got over
In
nothing
this
to it.
case, as I find, when we started,
Where is that order which says that otherwise 10 kilometers 10?
By dint of this
No.
order, my lord, itself.
Not this.
If
I think
and also, my
It
lord, this-
cannot be because here be declared by by the MOEF. That MOEF by the MOEF, the declaration be made by the MOEF at the earliest. The MOEF has not done. So if the MOEF and the court found it that it is necessary, the court cannot declare. It is something like today I ask the authorities out there to say, you kindly consider and appoint him.
in
Then you
fact,
say, are you going to say that this court had appointed him?
No.
Something like that.
in fact, my lord, if this comes, MOEF or notification also comes, my lord, it will be barred under, my lord. This they have also annexed some other proposals of other sensitive zones, my lord.
But
Setting
the
up-
order which has been passed is because of this.
because of this. No, my
Then
lord,
obviously that order has to go in view of that Govardhan Bhandri's case, 1952, page 16.
in that case, I'll request some more time. I'll produce the other orders of the good government case, my lord, because
You have another order passed.
yes, this is not isolated. After this, my lord, there are some other also orders of passed. Even in those cases, my lord, where there has no declaration, my lord, that 1 kilometer also stands. 1 kilometer and 10 kilometers stands, my lord.
Where?
Government's case, my lord. MOEF not, and also my lord will hold that my instructions, my lord. Since,
Your instructions cannot be again. Are you saying if your instructions are these, are you saying that this particular provision holds? It's a declaration by the Supreme Court. Is that the contents of your instruction?
my instructions are a bit different, my lord. And it says, my lord, since that boundary is not finalized, there are also petitions pending. And even, my lord, recently a case has been filed which has assailed the establishment of this park itself. The establishment of this park itself has been assailed, my lord. So
No,
in
the
that case,
judiciary is doing all the things which are necessary. But the executive is not exercising the power to do what is required. Yes, the Supreme Court under 141 can make a declaration. That's a different thing. But the Supreme Court did not think of making the declaration. The Supreme Court says the MOEF will declare. MOEF has not declared. The proposal has not been received.
proposal cannot go, my lord, because boundary has not been finalized.
So you can't finalize since 1996.
they have sent the proposal.
Petitions, my lord, petitions are pending in this
So
court,
does
my
it
lord.
take so much of time for you to finalize? This order was passed when some 12 something.
18 we got.
Order is there is a
Order
date
was
of the order.
18.
Otherwise, I leave it to lordship.
No, you don't leave it to me.
No, I'll leave
But-
it to lordship because it's a brick lane, my lord. It's a reserve forest, national park. I'll leave it to lordship.
No, you show me any other, no, because the order has to go. Because order is based on this order.
my lord.
This order does not say anything.
Well.
If you have any other provision, you can stop him for other reasons. That liberty is always there. But this order has to go. He's only challenging that order.
In that case, lordship, I will grant me some time. There are some other judgments passed in this Goda government case. Some other, after this, my lord, some other issue judgment has also been passed. This
No,
IA,
then in that case, you can very well take it because you see the order which has been passed is based on this order.
my lord.
This order is dated what? 11/12/2018. This order which has been passed by the way that the DCA's order. Yes. Kindly come to page 195, 125.
125.
You are challenging this order, no?
Yeah.
Whereas the BBI own so-and-so is located in the eco-sensitive zone of Povitola Sanctuary and the undersigned considered it pertinent and urgent to invoke so-and-so for in pursuant to the order of the Honorable Supreme Court in so-and-so. And the order which have been reflected out here is this order. Because you the previous paragraph you see And who is the deputy commissioner? Morigaon. Who is appearing for the deputy commissioner Morigaon? Yes. On what basis did you pass that order? Which order did you refer to? Which Supreme Court order did you refer to on 2/3/2019? You have not even mentioned the date.
Prior to that, we have received a communication from the DFO, whereby that order of
Which order? Is
That is
that
that
is that
page-
the order of
page
2018?
WPC 202.
Mr. Borua,
Okay.
202 is passing orders from 1996. Which order we are referring? Is that the order which is there at page 135?
Page 124 last paragraph, he says that he got this judgment of Justice Lokur from the DFO, and on that basis. he-
No, that is why he is not mentioning which order.
uh, Page 124, Mullah,
Yes,
where.
he is not saying which order.
Yes.
That is why I wanted to see which order you are referring.
And
So
closing
do you have the
order-
copy of that notification? That communication, do you have a copy of the communication?
It's in my
DFO 18/2/2019.
And closing the order of the Honorable Supreme Court passed in relation.
You have that?
Yes.
Where it is?
In fact, that communication from the MOEF.
You have enclosed it somewhere.
Yes, I have enclosed it in my affidavit
Affidavit filed by
filed by the deputy commissioner.
when?
So, take to the last page, the communication from the MOEF for the Deputy Inspector General of
Yeah.
Wildlife.
18/2. Yes, this order.
Yes.
So this order does not say that it has been declared. So your entire basis of this order goes. Mr. Gogoi
declare-
wants to take some action, take action, which is otherwise permissible under law. I'm not stopping you from doing it, but this communication is based on an order where the Supreme Court did not make a declaration. Or is there any order, Mr. Gogoi, that wherein it has been said that till the declaration is made by the Ministry of Environment and Forest
I'll come to page number 112
of
this petition, whether there's an order passed by the Honorable High Court.
yes. That is an order passed by the Deputy Commissioner again.
No, that's.
Yes.
The Supreme High Court order, my lord, it starts at page 109.
Yes. What does it say?
Order, which order?
109.
Where? What does it say?
It indicates there's an earlier order of 2012 was passed, wherein my deputy commissioner was asked to direct it to pass a fresh order, which is passed into 1112. If we go to my lord, that other order, which starts at my lord.
Mr. Gogoi,
Hello.
enough. We set aside this communication.
Well, I'll request some time.
For what?
Lord will grant me some time.
For what?
Because Godabam and some other orders have been there, madam. Are there, madam?
Okay, 7th
Yes, ma'am.
is the matter on 7th.
Not 7, my lord, I did not hear it. 7, I'll be not here, my lord. Take it on 50, my lord. I have to go for.
Okay, tomorrow?
No, not tomorrow, my lord. Oh, my lord.
Okay, we hear you now. We hear you now. What is there? I heard you, Mr. Borua, on the last occasion. You see, what you are saying, you see, Mr. Borua, whatever may be, the order is based upon an assumption that it is an eco-sensitive zone passed by the Supreme Court. And that assumption is what Mr. Gogoi is saying. But there is no assumption, it can't be assumed on the basis thereof, unless the Ministry of, because there is a specific direction to the Ministry of Environment and Forest to pass the declaration.
That is true.
That is the law of the land.
That is the one of the issue. Other issue, my lord, must be kindly considered because whole my lord thing is started on the.
Mr. Borwa, this court is only going to set aside the deputy commissioner's order and direct him to pass a fresh order. Taking into account whatever other circumstances, but not this order can't remain. That's all. What is there? I don't understand, Mr. Gogoi. What is your problem? If the deputy commissioner considers some other aspects, you place it before. But this order, can you say that it can be sustained on the basis of the reasons so given that it is an eco-sensitive zone? It is not an eco-sensitive zone. And if it is in eco-sensitive zone, it can't be on the basis of that order. That's all. Thereupon, if there is, because the basis of that order is that. And if you see the affidavit which has been filed by the deputy commissioner, he says that that is the order where he has enclosed out there to his affidavit. The DFO has brought only that order of 11/12/2018. So this order has to be set aside. There's no way out. The only thing you may do thereupon, I'll ask the deputy commissioner to pass a fresh order, taking into account of relevant facts and circumstances to that.
That will not be-
Because we will say by law, if the past order, this shall be made. Kindly see the.
Page 76.
order, my lord. Kindly see the reserved order, my lord.
we can do.
Yes, where?
Please.
Because in fact, my lord, the deputy commissioner didn't comply with the order of the division bench. Is at page 121, which is based on a written settlement between the parties. So, Lordship has seen that.
The consensus order.
Yes, sir. And he said that give a hearing and take all the relevant facts into account and pass an order. He gets that order and passes this order. So he should go
No,
that. order.
you know, as there is a direction passed by the division bench to pass an order, this court will permit the deputy commissioner, but not on the basis of that document or order of 11/12. You take whatever, let the deputy commissioner decide whatever may be. I'm not on that.
Yes.
Mr. Gogoi, you can very well go to the deputy commissioner and show him any other judgment of Godavari now. I think that.
I'll leave it to lordship. My only another anxiety is this is my lord, this is Brickley and the area in question is a national park. That's all.
Understood.
My lord, set aside.
No. There's nothing else.
My lord.
Lord, kindly see page 122. Last. Kindly see. Revision order. Last.
122.
Page 122 of the. My lord. Last critical pilot. So accordingly, as your authority.
Now you are saying that and which exercise be completed within an outer limit period of 4 weeks from today, the status quo as obtained today, obtaining today shall be maintained by the parties. You want that? So that will remain. We'll make it very clear. We'll make it clear that the status quo will be remaining and we direct the deputy commissioner to dispose it of within 1 month.
Whatever time you are talking.
1 month.
And
Can
here-
the
here
deputy
both-
commissioner do it?
Here both the parties.
Yeah, but do it 1 month.
All the parties.
Yes.
As per each order.
No,
my lord.
it will be the same which has been given by the division bench.
Yes.
Only thing, this order cannot be sustained in view of that it was not there.
Yes.
Hello, we'll dispose it of. We'll set aside that thing
My lord.
and maintaining the status quo as given by the deputy commissioner, by the division bench till the disposal of the deputy commissioner's decision.
And your lordship will say that he will abide by the order of the directions of the deputy. Because he has directed.
Division bench direction is there, whatever direction it is there.
Perhaps. And
We are
That is on the basis
we are
of
the
agreement
affected
of both
party, my
sides.
lord. We are the affected party.
No,
All
by
these
a
established by law,
agreement.
our whole
Mr. Borua, I have all sympathy for being the affected party, but you see, unless the Ministry of Environment and Forest, unless the Forest Department does in consonance with the direction passed by the Supreme Court, this court's hands are tied,
That is the one of the.
or this court has to believe
So that
that
is
the
the-
Supreme Court had declared, which the Supreme Court did not.
so that is one of the issue, my lord. Other issues, my lord, is whether our plan will go, my lord, if it established, my lord. The report from our agriculture officer also said, my lord, if the.
He will consider everything.
The whole.
Mr. Borua, all these things will be taken into account by the board. You see, the reason why he has done is was the eco-sensitive. So eco-sensitive, it is not there. So we set aside that and they ask them to show, you show any other order, take the help of Mr. Gogoi and so.
As on now, my lord, as per order very fast, as per the duty of this order.
That is, it will go back to the state division.
Again, we will other, he or we will come, my lord. Then there is six
This
order
one is not
litigation.
for our
That is the
prestige.
six order litigation, my lord. External litigation.
I'll pass the order
Deep job,
because I have to narrate some facts.
Yes.
while
deep job.
Lordship, I'll seek some liberty.
For liberty for what?
The Supreme Court orders, after there's some other orders are passed, my lord.
Let you see what is there. The
No,
court has
that has been
division.
reiterated.
No, Mr. Gogoi kindly appreciate. The Supreme Court categorically in that order, which was the basis of the order of which had been impugned, is states for the Ministry of Environment and Forest to pass that order. To issue a declaration. That declaration has not been passed. The Supreme Court never declared that 10 kilometers would be.
No,
Now, thereupon, that is the basis. Thereupon, if there is any further order, point it out before the DC.
Yes.
That is what I'm saying.
Ah.
I'm putting you again back to the state of what is the direction of the division.
correct.
But Lordship will not kindly not restrain us. That,
No, no.
But
You are-
Lordship will dispose it out, but Lordship will, may not pass any restraining orders against us.
No,
No,
that
you-
status
Yes,
quo which
what
has been
happened, my
given.
lord? We face. my
No,
lord,
Mr. Gogoi, the status quo order which was given by the division bench will be respected.
My lord,
That's all.
There's no problem. Deep job.
issue is that, my lord,
Pilot 17.5 data. Page 34, the minute of the subdivisional level land advisory committee. Page 34. 17.50 letter. Thereafter, my lord, page 47. The deputy commissioner has forwarded letter to the government for approval, madam. Page 47.
And
Page 47, 28 to 2017.
Earlier, they were given allotment, and thereafter they are claiming for settlement. That proposal is pending with, as they say, pending with the department. We have written, but no instruction has been received as yet. Lord, you may kindly grant us some time so that I can get the instruction, because it has come up after a long time.
so the approval has been given on
Yes.
18/11/2015.
That is allotment.
So the proposal is being submitted to the government in the year 2017.
This is for settlement.
A proposal for settlement.
Settlement.
So settlement, the allotment is same. Is it different?
Earlier, initially they are given allotment.
Allotment where? Allotment under what provision?
So as per land policy matter, that is, it is written as allotment stroke settlement.
So
But-
it is a settlement only. Where is it? Here there is only an approval for allotment.
Allotment.
So that has already been given. That
Yes,
can be
yes.
seen from page 47.
Yes, yes.
Then why haven't you not taken any action for the last 6 years?
That instruction is awaited, madam.
The earlier occasion, my lord, so many times was taken by the government. Taken it.
No, it has come up after a long time, madam. Therefore, I will pursue, madam. But you may kindly grant us some time.
The perusal of the writ petition. And again, the instant writ petition was filed by the petitioner, taking a direction upon the respondent authorities, more particularly the revenue department, to complete the process of settlement of the land in favor of the petitioner, measuring 17.5 letters covered by dark number 771 part of Revenue Village Ananda Nagar under Bilasipara Revenue Circle of Dhubri district with the petitioner on receipt of the due premium. This court have duly taken note of that on 18/11/2015, the state, what is that, SDL,
Subdivisional Land Advisory Committee.
Subdivisional Land Advisory Committee has approved the settlement to be made in favor of petitioner. Thereupon, the Deputy Commissioner Dhubri had by the communication dated 28/2/2017 had submitted the same to the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department for passing necessary approval so that the Deputy Commissioner Dhubri could settle the land in favor of the petition. 6 years have passed by, but till date, the revenue authorities have not done. Though this court had issued notice as far back as on (19/12/2019). List the matter again on 15th of September 2023, on which date Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the Revenue Department, shall apprise this court what steps have been taken by the revenue authorities, by the Revenue and Disaster Management Department, pursuant to the communication dated 28/2/2017, issued by the Deputy Commissioner Dhubri. It is made clear that till the disposal of the instant writ petition, the petitioner shall not be evicted from the land wherein the petitioner is in occupation.
Like,
14.
but the last one, direction has given. Take it.
Yes. Who is there? What instructions you have?
Yes.
What happened to that?
Uh, submitted on 29/4/2009 and 19. And what happened that on that regard instruction not received, they are trying to find out that some
You submitted before whom?
SP. On
Where did
last
you
occasion,
submit the final report?
on they had submitted only when it was filed,
Where?
where it was. Whole instruction is not find out now. I have communicated with them and they asked for requesting for 2 days lordship. In our whole instruction.
The instruction which was sought for by the order dated 25/8/2023 to the effect as to what happened to the final report dated 29/4/2019 and before which court the said final report has been filed had not been forthcoming from the respondent authorities in spite of opportunity given for the date. Opportunity given on 25/8/2023. Mrs. S. Purva, appearing on behalf of the respondent authorities, have placed an instruction issued by the Superintendent of Police CID AHT Assam, wherein also it is only mentioned that the state final report was submitted on 29/4/2019. This court further fixes this matter again on 8th of December, 8th of September 2023, on which date the respondents shall ensure that the query so made by this court by the order dated 25/8/2023 is duly answered. List according.
Applies.
He to file, he then has to know. He doesn't know anything.
Yes.
And madam, you are saying all these things. If I had the time, I could have find out in 5 minutes. I can ask these people. Now with the CCTN thing, you can immediately find out. I don't understand why they don't know. It has been all amalgamated.
Yes.
There must be something wrong with your superintendent of police while he has done this. It doesn't take much time.
Yes.
Just put that number out there in the CCTN. It will show in which court it is, whether notice has been issued, everything. You only forget about anything. You just put the FIR number, you will get it. And he can't find it out.
15 and 16.
Electrical matters, no, my lord.
Hmm?
No, time is to try seeking the compensation that is, your losses, that is the thing, the matter, that matter. Lordship has directed me to obtain the award on the last occasion, my lord. I have obtained a copy of the award statement, Lordship may peruse it, my lord. Unreadable.
Award in LA case number 18 of 2000. Both are same.
Both are same, my lord.
You are agree with the compensation.
My lord. My lord, because it was.
And why the both petitions are filed? Who is Kamakya Realtor?
Hello?
Why is Kamakya Realtor's matter here?
Yes, that is also same.
In respect to same LA case,
Yes,
same LA case,
same election.
18.
Yes.
When was the award? What is the date of the award?
My lord, date is, my lord. The date night. Itu pada date but. Itu ada positif. Kono itu. Objection.
In both cases, Mrs. Ayala, you have received the amount.
No, our my lord, notice has been received, but my lord, because it was fixed as actual length, although it is a my lord.
Maybe, but you have been asked to give all these documents for the purpose of payment.
Yes, my lord.
You can receive the amount without under protest.
Yes.
Isn't it?
In this proceedings.
Because what happened, once that notice is issued, the interest stops.
Yes. I-
There the problem arises. You
Right.
unnecessarily lose
My lord,
on
I
the
can
interest.
receive the.
It was initiated under the 64 Act and my lord, compensation has been determined, my lord, as per the parameters of 2013 Act. Since there is a, my lord, notification from the state government of 2015, which says, my lord, that the formula given, although proceedings may be there, because that proceeding 64, my lord, prescribed for a, my lord, simpliciter proceeding. So therefore, my lord, authority.
Mr. Barbujari, whether that notification is there or not, by dint of 102 or 103, you are bound to give that, isn't it?
That notification.
That's the bound, unless you come under the Schedule 4. And Schedule 4 was only for 1 year.
Yes.
So that becomes useless.
And therefore, that
You have
notification
to.
has been issued under 102.
Huh?
102. That
Oh, you have
notification.
to, you are bound.
Yes, we are bound.
So whether a notification issued or not, that is immaterial.
Right.
Now, here it has been done under this, so they will apply before the year for.
Yeah.
Under section
The
12.
only reason that my lord has sought for this, my lord, award statement on the last occasion, since they are disputing, my lord, the classification of land. That's all.
What is the classification of
So
land?
they say, my lord, that it should be, my lord, more.
It is, in one case, my lord, it is a commercial and other case is industrial.
Kamakya is what?
My lord, that's same. Yes, page 77, that my lord, it's a Solaram Bapna, your lordship will find. It has been declared as public and semi-public zone. So it is commercial matter. And the other is industrial. That is at page 82, my lord. In Kamakya real estate.
In the award statement also, their name is reflected against the Patadars, my lord, Tularam Bapna.
Where?
My lord, in the bunch of papers, my lord, which I have just now handed over to my lord. There, my lord will kindly come to the second page, my lord. The award statement, 2 pages. The first page, my lord, will see, my lord, on the left-hand side. My lord, 1, 2, 3, serial number 194. Tularam Bapna Kritim Bhori. Aru Obhibabok Caliper Kendra.
Table draft method. Virtually they are.
No, I am going by the award, my lord. What is there in the award? Then the next page also, lordship will see, my lord. On the left-hand side, it is serial number 191. Tularam Bapna Kritim Bhori Aru Obhibabok Caliper Kendra.
And when did you get the notice in this case?
My lord,
And some people have, my lord, already received the award, my lord, under objection, although, my lord.
Huh?
Some people have already received their quantum of, my lord, awarded money, although with objections. That, my lord, will find at the second page of that bunch of papers, my lord. Second page, my lord.
my lord, at page 102, my lord, it is in dollar of.
But you have not taken the money. You have been asked to submit these indemnity bonds and all. These were given in 2019. You are not interested with the interest. Now, how can you get interest? Tell me for this period. And this amount is something huge, 2 crores. Then the other is 70 lakhs. Now, taking into account the interest involved will be how much?
My lord, the other persons are also there, my lord. Not only. My lord, actually segregation is also part.
It will be done by not by the collector's office, my lord.
104, you also see, my lord. All the names are there. How much is to be received by whom, my lord? You know,
Look, the instant writ petition has been filed by the petitioner. Seeking a direction to the Deputy Commissioner, Kamrup Aminda, come collector, to determine the compensation as regards the land acquired from the petitioner as a commercial land to determine the compensation of the land acquired by the petitioner as commercial land and not as agricultural land. A perusal of the writ petition shows that the petitioner herein is a society registered under the provisions of the Societies Registration Act 1860. The said society has various plots of lands It is the further case of the petitioner that pursuant to the issuance of the master plan and the zoning regulations of the Greater Guwahati 2025, the land wherein the land of the petitioner have been lands of the petitioner falls under the public and semi-public zone. It further reveals from the records that a notification bearing memo number KRA.140/breach/2017/102/740 dated 8/6/2018 was issued under section 3.1 read with rule 3, section 3.1 of the Assam Land Requisition and Acquisition Act 1964 for requisition of various plots of land. In the same notification so issued, various plots of land belonging to the petitioner were included. It is further seen, on the basis of the said notification so issued, a land acquisition case being LA case number 18/2018 was registered. Subsequent to the issuance of the said notification, on 14/9/2018, another notification was issued under section 6.1 of the Assam Land Requisition and Acquisition Act 1964, for short, the Act of 1964, stating inter alia that the collector Kamrup was pleased to decide the acquisition with effect from the date of publication of the said notice of the land, which was requisitioned under section 3.1 of the Act of 1964, of an area at measuring 46 bighas, 3 kathas, 14 lechas in village Goripur, Moza, Sila Sinduri Gopa, in the district of Kamrup, for construction of bridge over river Brahmaputra connecting to Guwahati, not Guwahati. Here the petitioner's name is there.
No, my lord, here and others, my lord, sorry, 31 and 32.
Huh?
Page 98, 31 and 32. All the names are not given, my lord. Only first name is given.
Of 486.
Yes, yes.
Huh?
Page 98, if you notice, see, my lord. Serial number 31 and 32. These are our plots, my lord. Here, some other persons land is here.
We are concerned with serial number 31,
31 and 32,
486 and 487.
my lord. Because other persons land is also there. So, and others they don't.
It is the case of the petitioner that in the said notification issued under section 6 of the Act of 1964, the land of belonging to the petitioner have been mentioned at serial number 31 and 32 of the said notification. That is, lands pertaining to DAG number 486 covered by Patta number 102 and DAG number 487 with the corresponding Patta number 101. Full stop. It is the case of the petition, further case of the petitioner, that in the said notification, the said lands, although have been classified in the master plan as
Public and semi-public.
semi-public and what is that word?
Public and semi.
Public and semi-public.
Yes. Public and semi-public. No.
Public and semi-public was, however, classified as agricultural lands. It is therefore the case of the petitioners that the computation of the determination of the compensation was not done properly by the respondent by the respondent collector while awarding the compensation in terms with section 11 of the Act of 1964. It is under such circumstances that the instant writ petition was filed under Article 226, seeking a direction upon the collector to redetermine the compensation by taking into account that the land belong to the lands are commercial lands. This court have duly taken note of the materials and record and have also heard the learned counsels for the parties. This court finds relevant to take note of section 12 of the Act of 1964, which stipulates as under Potko. From a perusal of the section of the said section, it would be seen that in terms with section 12(1)(a), if a person is aggrieved with the inadequacy of compensation, the person concerned can file an application before the collector. The collector, as per the provisions of the said section, a statutory duty is cast upon the collector thereupon to refer the said grievances of the person concerned to the court. This court further finds it relevant to take note of subsection 2 of section 12, which stipulates that the provisions of the Land Acquisition Act 1894 shall duly apply mutadindi to the provisions of to a reference to be made under section 12(1) of the Act of 1964. Accordingly, the provisions of section 18, 19, (31)(2) of the Land Acquisition Act 1894 would duly apply. This court further finds it relevant to take note of that once an award has been passed under section 11 of the Act of 1964, the collector becomes functus officio. Under such circumstances, this court at this stage, after the passing of the award, cannot direct the collector to redetermine the compensation. The redetermination of the compensation, therefore, has to be made by the court, as have been defined in section 2, what is that? 1964 Act.
64.
1964 Act, the court has been defined in section 2C or something. It has been defined.
My lord, the court means the principal
No, no,
civil
section?
court. My lord, section 2B.
Has to be decided by the court as defined in section 2D of the Act of 1964. In that view of the matter, the writ which had been sought for the writ of mandamus which have been sought for by way of the instant writ petition cannot be issued, thereby directing the deputy commissioner or oblique the deputy commissioner Kamrup oblique the collector to redetermine the compensation at this stage. Be that as it may, taking into account the provisions of section 12 of the Act of 1964 and reading the same along with section 18 and 31(2) of the Land Acquisition Act 1894, this court grants the liberty to the petitioner to submit an application before the collector within 30 days from the date of the instant order. Stating inter alia, seeking a reference within 30 days, seeking a reference to the court as regards the inadequacy of the compensation. This court further directs the collector, Kamrup, that is the deputy commissioner, is the deputy commissioner, that is the deputy commissioner, Kamrup, district commissioner, Kamrup, to, upon receipt of the said application, to forthwith refer the said dispute, refer the said dispute for determination by the court within 15 days therefrom. With above, the instant petition stands disposed.
The other case follow the only follow that is different. That was industrial land. The second and name and other things follow.
It's an industrial area as per the master plan. And which is the dark number?
Well, okay, thank you.
Industrial.
My lord, if you
We are
also see
concerned with
page
that
82,
number?
my lord, first, page
Huh?
82.
83.
82, my lord, that is industrial.
Okay, but we are concerned with dark numbers.
Tag numbers, my lord,
And
One
serial number.
serial number 6, 7, 8, 9.
Itu agote apna 31, 32 asil noy. এইটো 6, 7, 8, 9 হ'ব ঠিক আছে বাকীখিনি প্ৰায় একেই has various plots of land concerned with dark number 180 corresponding to KP Patra number 27 120 corresponding to has land at dark number 118 120 121 and 123 corresponding to KP Patra number 27 at village so and so বাকীখিনি একেই হ'ব
Lordship, maybe please to
Well, the past
retain that award statement as a part of the record, if my lord chooses.
the এই তলত লিখি দিব the Mr. R. Borpujari pursuant to the order passed by this court এইটো আগৰ ৰিপিটিশ্যনত দিব দেই নেক্সট খনত নহয় ছেকেণ্ড খনত নহয় ফাৰ্ষ্ট খনত pursuant to the order passed by this court on 21/8/2023 had produced the instructions along with the award statement which is kept on record and marked the letterheads.
I'm so obliged.
Second section, my lord, the first para will be changed one.
Eh?
First para will be changed.
No, that will be changed. That don't worry, they will do it.
Well, much.
Obliged.
17.
Yes, madam. You are supposed to file affidavit.
No, Lordship, this is item 33, Lord. This is another case.
Oh, 10 days. Yes, tell
In
me.
this case, Lordship, what happened, they are claiming interest on delayed payment. Lordship, may come to page,
You are supposed to file affidavit.
Lordship, could not file, Lordship,
You want to concede? It's okay.
no, Lordship, here, on the basis of the impugn order, I can submit, Lordship. Interest, they are claiming interest for about 20 years. Lordship,
Oh, that amount. That period,
Yes, Lordship.
when there was a direction passed.
Yes, Lordship, here,
But I think you should file an affidavit.
I'll file.
Because this is a very contesting matter pertaining to
Yes,
that. Why is, yes, it is in the impugn order is there, but I think you need to explain that.
I'll allow me some.
When
2
we
weeks.
have already given you 10 days time earlier.
Lordship, I'll file by 7 for it.
Okay. The learning council appearing on behalf of the GST further seeks for an accommodation of 7-8 days for filing the affidavit. List the affidavit in opposition. List the matter again on, yes, when?
After 2 weeks.
You, when? Your senior is not there. That is why you have taken on the last occasion.
After
The
September
matter
20,
on
Lord.
13 September. Full stop. The affidavit be filed by 11 September.
Obliged. 18 and 19.
Oh, this one.
It
Where is the revenue? They are not giving the permission for the mutation on the basis of that transfer.
Amalgamation, merger order.
Yes, Mr. Doctor.
Arbor project is conducting the matter.
Eh?
Arbor project is conducting the matter.
Arbor Pujari, where is he gone? Earlier, Miss P.R. Mohanto was appearing.
After some time, Lordship, I'll call him.
Okay. We'll have it.
20.
Yes.
One very important issue arises in this case, my lord.
Hmm.
Lordship knows, my lord, the municipal act was amended pursuant to, my lord, Article 243W.
Hmm.
Whereby, my lord, it was mandated that this permission and all this should be dealt with only by municipality. Now, the present practice is planning permit is being issued by the, my lord, KMDA, and the building permission is given by EMC. My lord, the constitutional mandate is other. And in fact, Government of Assam has amended the act also, whereby section 53A was added,
Of the
municipal act.
Assam Municipal means GMC,
Yes, Assam Municipal Act.
56.
Yes, in 2011.
Ah. But there you don't have the GMDA problem as per the Assam Municipal Act.
But I think same principle will apply to even to corporation also. That's a larger issue.
Hmm.
Immediate issue was, my lord, the then minister, he formed a committee comprising of himself and few officials to give permission.
Oh.
That was stated by this order.
That
Lordship
aside,
will
it
kindly have a
was
look
the
at the
letter
impugn
dated
order, my
demand
lord.
issued by the Undersecretary to
Page
the government,
30.
including the HIPAA constituted by the state. Now who is doing it?
So now,
No.
normally, after stay order,
Then what do you mean?
Now, as per the act, my lord, you have to give a application to the GMDA. Planning, they will look after it. Planning permit is issued, sent to online to GMC. GMC to the
So now you have a procedure.
right.
You are happy with the procedure? No, I am asking you. That is the
Okay.
reason why. If you are happy with that procedure, then why should this court remain?
My lord can do one thing, my lord. As far as this issue is concerned, by making the interim order absolute, writ petition can be closed. Regarding the other issue, my lord, liberty may be retained.
So that is what I am asking. If you are happy with the present procedure, then why should this court deal with this issue? Huh?
It was done by the.
Let's keep the instruction of because the affidavit has not been filed.
You, because if you are happy now with this
That's what I-
procedure, then it's okay. Why should we go into all these things as regards the legality and all these things of this? We'll close it now. The
fact,
present
my lord-
procedure, what is the present procedure followed? You just put it on affidavit. I'll ask you to direct him. I think that is a,
My lord,
Still posted after 2 weeks.
the instant writ petition was filed by the petitioner challenging the memo number GDD.109/2009/PT-Roman 1/809 dated 19/10/2020 issued by the Undersecretary to the Government of Assam, Guwahati Development Department, including the High Power Committee constituted by the letter. Full stop. This court, by an order dated 4/2/2021, by the detailed order dated 4/2/2021, issued notice and in the interim provided that until further orders, the single window clearance committee, instead of inverted comma, single window clearance committee, constituted by the impugned notification dated 19/10/2020, shall not in any manner interfere with the functioning of the GMDA and GMC authorities in discharge of their statutory functions as per the provisions of the Act of 2010 and the bylaws of 2014 with regard to the sanction of planning permit and building permit. Full stop. The learned counsel appearing, this court had put a specific query upon Mr. S. Bora appearing on behalf of the GMC or GDD, everybody.
he appears with both,
GMC,
sir.
GMD, not
But this order is being passed by the GDD.
GDT also.
GDD also
GDT.
appearing on behalf of the respondents, which includes the GDD, the Guwahati Development Department, comma, the GMC, as well as the GMDA. GMC is not a party,
GMC is not a party.
not a party. Appearing for the GDD as well as the Guwahati Metropolitan Development Authority. As to what is the present practice followed in view of the stay of the order, in view of the interim order passed by this court on
16, 12,
4/2/2021. This court, the learned counsel appearing on behalf of the respondent submits that he would like to take instructions in that regard. And a present practice followed pursuant to the order dated 4/2/2021 And as to whether the present practice has been working, has been satisfactorily is
As per the legal,
is providing the desired object. Full stop. The learned counsel appearing on behalf of the said respondent submits that he will take necessary instructions in that regard. Mr. Matte again on 18th of September.
Hello.
Full stop. In that, we'll fix it on 20 September 2023. The respondents are directed to file an affidavit by 18th of September, answering to the queries so made in the instant order.
21.
Lordship, I want to withdraw this petition.
Oh, you want to withdraw?
Lordship, there is some discrepancy with regard to the drugs. Lordship.
Huh?
And this is a petition for non-consideration of representation of the petitioner for conversion of his annual portal land to periodic portal land. There is some discrepancy with regard to the drug numbers. Lordship. And secondly, Lordship, they have already heard that concerned plot of land has already
To
been
direct to dispose of the applications of the petitioners to conversion of so and so. So they are not doing it.
not being.
Why?
But now recently they have heard, Lordship, in Bosundhara scheme, they have converted this annual patta land to Myadi patta land.
They have done it.
Lordship, they have not confirmed, Lordship, but they have heard, the petitioner already heard that.
No. So now as per the Bosundhara scheme,
Lordship.
you have duly applied.
No,
Again applied.
I have not applied in Bosundhara scheme. Lordship. I have applied in the year 2015 itself, Lordship, when before launching of the Bosundhara scheme.
Now, how did the Bosundhara scheme got invoked if
Because
you have not applied?
I have not applied in Bosundhara scheme because in Bosundhara scheme, this land cannot be applied, Lordship. Certain other, in the patta, Lordship, there are certain other dogs also. Certain people have applied for conversion of their
Now,
land.
what do you want?
Now I want to withdraw this state liberty to file it appeals if instructed.
Why?
Because they have filed an affidavit in opposition in this petition. Lordship. So they are stating that certain other peoples are occupying my plot of land. In that regard, I have to specifically need to say which area I am occupying. Lordship.
The learned counsel appearing on behalf of the petitioner submits on instructions that taking into account the stand which has been taken by the respondent authorities in their affidavit, the petitioner may be permitted to withdraw the instant writ petition and file afresh by bringing on record various other details by giving further specific details as regards the land in their occupation, in the land in their occupation. So taking into account the above, the instant writ petition stands closed on withdrawal. Full stop. Liberty as prayed for is granted.
Obliged, Lordship.
22.
With the Lordship. Lordship, I mentioned the matter, Lordship. The petition authorities have filed their affidavit day before yesterday, your Lordship. And it's some.
I remember 33 lakhs.
33
See,
lakhs, Lordship, 25% paid, and again pay.
you have only paid only true. How much?
25, first 25%, Lordship.
How much you have paid till now?
That would come to Lordship, 33 lakhs, 20.
However,
paid
how
almost
much you
like,
have paid?
15 lakhs, Lordship.
Huh?
15 lakhs I have paid, Lordship.
Then how is the APDCL going to run?
Just my
You are challenging a provisional assessment bill.
Lordship.
Appeal?
Appeal, Lordship, they have rejected, Lordship. Review also rejected. Lordship.
Then what is the legal point on which this court should adjudicate? Tell me, if the appeal has been rejected,
Lordship.
so the facts are ascertained. This court can't touch on the facts. What is the legal point on which this court?
Other legal thing is that the procedure that was followed, Lordship, while seizing the meter, that was not followed as per the Electricity Act, Lordship, and moreover, there are some notifications issued by the Electricity Act, APDCL authority that assessment officer has to be present while seizing the meter. Assessment officer should be present. I'm not holding the notification, Lordship. But
Is it
my-
required assessment officer to be present? Mr. Borua,
My lord,
what is he saying? It will have a serious connotation.
Lordship, in other.
If
in
the
one of the-
assessing officer has to be present in every meter change, you don't have so many assessing officers.
Well.
Then how do you take note of? You have a notification to the effect.
I'll produce it, my lord. I'll have to obtain.
If you don't have, how can you produce? Can you produce a non-existent thing?
No, my lord, to my knowledge, there is none. However, if your
I may
lordship
be
requires,
wrong,
I'll look
Lordship,
into
I
it.
may be wrong, but I've been through some notification earlier, your Lordship.
How much time to file affidavit? Reply.
Lordship, 2 weeks time. Lordship. Lordship may fix a date also, Lordship, and the person has to come from Silchar. The matter person.
Silchar is where?
It's nearby, Lordship, not that far, but
Now, I think we have flights also.
yes, yes.
Then what is the problem? The Mr. D.
DJ,
J. Das, the learned counsel appearing on behalf of the petitioner, submits that on 28/8/2023, an affidavit in reply have been received from the APDCL authorities. The petitioner would like to rebut to the allegations made therein by filing an affidavit in reply, for which 2 weeks' time has been sought for. List the matter again on 15th of September 2023. The affidavit in reply be filed by 13th of September 2023. Interim order passed earlier shall continue till then.
Much
Obliged, man.
23.
Where's the revenue? Arbor Pujari has not come. Yes, what is this? Oh, PWD is here.
My lord, usually-
Non-payment of tractor bill, madam.
Yes, what is your stand? Huge amount.
My lord,
We direct verify, pay. If he is entitled to pay
He-
as
he is
per
entitled, my lord.
Kamsar Ali.
my lord, my lord,
Verification within 1 month and pay as per Kamsar Ali.
come sir earlier,
But verification has to be done within 1 month
within 1 month.
and some paid as per Kamsar Ali. That's all.
My lord will grant 6 weeks, my lord, because it's a matter of Dhubri, because verification, ground verification, it will come to again in Guwahati. So 6 weeks. I'm asking just 2 weeks.
We'll
more,
grant you 2 months.
My lord, my lord. And
Verification 2 months, paid as per Kamsar Ali.
come sir earlier.
Deeply obliged. 24.
My lord.
Yes, Mr. Khan. What
My
are
lord.
these? You have reduced this court to a civil court. With all photographs and all.
Yes,
What
yes,
are you
yes.
challenging? To direct their considered a representation dated filed by the petitioner to remove the blockage caused to the path towards entrance of the dwelling house, for which as the same has been done without following any. Who has done that?
My lord, the respondents, my lord, they have constructed a fencing, my lord.
Huh?
My lord, what happened, my lord? It is in the Basista area, my lord, it is Bahini River, my lord. My lord, in between the land of the petitioner and the main road, there is Bahini River. And my lord, all the residents of that area, my lord, they have their own individual, my lord, like culvert, my lord, bridge, my lord, wooden bridge, small, my lord. They use that to come to the main road. Now, my lord, what happened, my lord, the respondents, they have constructed a fencing, my lord, permanent fencing, my lord. Thereby, my lord, they have blocked the entire passage, my lord. And what happened, my lord,
This is Bokhista,
Basista, my lord.
near that school,
Yes, yes,
army school.
yes. We need not reach till there, my lord. Just before that, my lord, from where the army hospital starts.
From there.
Yes, yes.
Well, I think that will be around 500 meters to the army school.
Yes, yes.
Yes.
my lord.
Then
Now, my lord,
what happened, my lord? Kindly come to the page 17, my lord.
Hmm.
I'll show the photograph. This is my land, my lord, blocking my land, my lord. Page 17.
Yes.
So, my lord, this is the small wooden bridge, my lord, leading to my land, my lord,
Hmm.
which they have blocked, my lord, through fencing, my lord. There is one vehicle is seen, my lord, and that fencing, my lord. This all these photographs, page 18, my lord, I have shown how they have put the fence. Page
No. This fencing, you are staying in whose land?
in my own land, my lord.
Then how are they putting that fencing?
My lord, they have put the fencing on the main road.
No, Lordship.
They have put the fencing on the main road.
No, main road is where? Your fencing, the fencing comes before the main road.
My lord, kindly see photo 4. That is the fencing, my lord.
Huh?
Photo number 4, my lord, page 18.
Yes. So the fencing and then the main road,
Yes, my land, then Bahini River,
then fencing.
then main road.
Yeah.
Earlier that fencing was not there, my lord.
So why is this fencing on your land?
Fencing is not on my land.
Whose
fencing
land?
is on the main road, government land.
So why you have put the fencing?
No, Lordship. That said land has been acquired long back, your Lordship.
This land also of the
Yes,
petitioner.
No, your Lordship. 1970, your Lordship, for the establishment of a military hospital, your Lordship. 2018, your Lordship, for the security reason, and his land, your Lordship, government land is bypassed by Bahini River, your Lordship. And your Lordship, the respondent has constructed installing anti-cutting fencing for security reason, your Lordship, not his land. And for the easy, your Lordship, localities for easy entry and pass, going, your Lordship, they have keep more than 20 gaps for easy conveyancing, your Lordship. And also his
But,
land
but,
is-
but Mr. Khan, have you taken permission to put this fencing, this bridge over that river?
But that is not required. This is
No, what is it not required?
My
This is the main cause of
my
all
lord,
problems.
my lord.
You have today taken it and I'll pass an order to remove this fencing, and in the guys later on, you will show that this court has passed an order allowing you to remove all these things, and tomorrow because of you the river will be clogged.
My lord, here, my lord.
Didn't you see in all the other places out there in the Korlu River, this has happened?
Exactly.
My lord,
This is the main cause.
my-
And this is not the road by which you can take a car.
my lord, we have not encroached the river. Bahini River is not encroached. In
No,
that
no,
area,
no.
my lord,
What is your, can you put a road above the Bahini River? Tell me that.
my lord, this is
We'll look into that other portion later on.
just a private bridge, my lord.
No. Can you put it above the Bahini River? That is a very serious thing which we have done.
Now, my lord, in that area, my that
I am not concerned with others. I am only concerned with you. Do you have a right to put a bridge over Bahini River for your ingress and egress? Tell me.
that is how it is done. Kindly come to
No.
page
How it
26.
is done? No. It has to be done as per law. Because the moment I say this, I will be putting a stamp of authority on this bridge.
My lord, my only case is, my lord.
Yes, Deputy Commissioner and the revenue. Tell me, is it permissible? See the photograph. Yes, revenue. Who is there for the revenue? You see, this is a very important thing which has cropped in here. In that, you see in the beyond Bokisto, beyond that Bokisto Sariali, you go towards the army, Bokisto Monde. On the left hand side, you will find a lot of the Bahini River is flowing. And there is a fencing being put. Petitioner agree with the fencing. Now, what is happening? They are having houses beyond the Bahini River. So the fencing is there, the road is there, then you have the fencing, then you have the Bahini River, and then their house. Now, what they are doing, they are putting a wooden temporary bridge by that over the Bahini River. Now, can it be done? See the photograph, what they have done. Now, can that be permissible? Because now what he is asking is, because of this breach, they are connect, which is there is a land which belongs to them or not, that is not known. Their land is prior to Bahini River. So this bridge connects to another land. That land belongs to the army. So army has put a fencing between that land and the road. And thereby then their ingress and egress from the road has been stopped. Now you see these type of bridges.
Right.
Now these type of bridges today is there. Today this court can direct them to remove this. Wouldn't this court be putting a stamp of authority on this bridge over a river? Where you need permission to put anything because you are breaking all the Bhorlu. On top of Bhorlu, any bridges are constructed by anybody, you are breaking it.
This is almost on the level of the water level because normally the heights are being observed for which those bridges
No,
have been.
don't you require permission?
Permission has to be taken definitely from the.
Can you have it
Yes, sir.
over a river without the permission?
Not at all.
You will have a far-reaching consequences.
Definitely.
Anybody can put anything over there.
GMC, no.
Perhaps one of the GMC authorities will be, because it is within their domain. GMC
The river?
and GMC and GMD authority. No, otherwise, Lordship is correct, my lord, so far as my lord, it may, my lord, amount to obstruction of water.
Water
flow.
logging, yes.
Yes, tomorrow it may happen.
Okay.
But if I put a stamp of authority saying them to remove the gate for their ingress and egress, would I not be putting a stamp of authority on this bridge?
Many a bridge will come up. Yes.
Everybody will come.
Yes.
No.
No.
This will have far-reaching consequences.
Legal.
And they are putting the gate out there or the what do you call the fencing out there in their land.
Yes, exactly.
So perhaps, my lord, they are doing it because they might not be having any
Lordship.
alternative path. That is one aspect of the matter.
No. That land has been acquired by them in 1970 and for which they have put a fencing
Yes, doctor.
in their land. Now, because of that fencing, they are not being able to ingress and egress.
So for that reason, they have put up that.
Huh?
For that reason, they have put up that.
No, they had earlier the breach. They were using the breach.
But here, my lord, difficulty is that it is within the domain of the municipal authorities. My lord.
Hey, can you put a bridge over a river?
Apparently, my lord,
My lord, there are numerous such bridges, my lord, which they have opened gate for them, my lord. Kindly see page 26 for a moment. Page 26.
people are
20.
doing it, my lord.
26, my lord.
People are doing it.
26. my lord.
26 is where? I don't have a page 26 here. What is the page?
Annexure 12, my lord.
Annexure 12, yes.
My lord, photo 1, my lord, will see, my lord, they have opened the fencing for this bridge, my lord, similar type of bridge. Photo number 2, my lord, will see similar type of bridge, my lord, they have opened the fencing, they have put a gate. So that in emergency situation, they can also put a lock there. Similarly, my lord, photo number 3, my lord, they have opened the fencing for this bridge also.
No, are there behind you, there is any breach over here?
My lord, this is how my the locals are commuting, my lord, to these small bridges, my lord, over the Bahindi river. My case is only, my lord, unequal treatment, my lord, with equals, my lord. For others, they have opened, my lord, only my part they have blocked, my lord, they have not opened.
So you want to get it closed? For
I don't
everybody?
want- No, my lord, others I don't want to get close. Just my lord, they can open, my lord, they can consider my.
Huh?
And the gates are of such a nature that they can lock it.
You have no other way to go to your house.
Yes, Lordship,
To others
his
land.
land is 20 meters away from our land. Your
No,
Lordship.
that I know.
Yes, in this area, I have filed affidavit opposing your Lordship.
I've seen it. Paragraph number 6.
Yes, the 10 also, your Lordship. I have also next some photographs. More than 15, Lordship, keeping gaps, your Lordship. And all I want is 120 meters break, your Lordship. So a man can easily coming and going, your Lordship.
Now what are you doing?
Your Lordship, paragraph 10, your Lordship, my affidavit, your Lordship.
Where are they? Yeah.
Yes, page 5, your lordship.
That as regards the government made in so that the present report on reiterated the anti-dumping tank has been directed by the expert over the defense land in Dhanagar, keeping in view the strength. Further, the respondent stated passages to maintain for best continuity. Wherever
Too
they
many
have
gaps, your
noted
lordship.
repetition
He can easily, your lordship, coming and going, your lordship.
to 50 meters away from both two-wheeler and four-wheeler. Equivalent to factory. Gap number 3, alternative 100 meters. Gap number 6 is what?
Yep. Land lease from army, your lordship.
Hmm?
Land lease from army, your lordship. Some land has been taken, your lordship. Additional land also taken for future any purpose, your lordship.
So you want this court should allow you to trespass upon the government land, their land.
No, my lord. Nobody is trespassing, my lord.
No, no, you are.
They have opened for others, my lord.
No, no, they have opened for others. That is a different thing. But they are saying that there are various gaps. You
Yes,
can
my
take
lord,
the
kindly see, my
alternative
lord.
route of 50.
50 meters,
Your
my lord.
lordship.
But are you not using their land to go there?
They are saying, my lord, that
Mr. Khan, are you not using their land to go there?
our submission, my lord, is that no.
No? Are you saying that beyond Bahani River there is land belonging to you?
Not me, my lord.
Whom?
The government of Assam, my
Beyond Bahani River, it is government of Assam land.
yes, this road leading to Vasistha Mandir. my
No,
lord.
no, 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 no. There is a gap between the Bahani River and the road. And that land is whose?
No, my lord, that is road, my lord, completely road, my lord.
Can't be. Kindly see the photographs. See the photographs out here. Let us see these photographs. At photo number 4, page 18. This is the bridge. There is certain plot of land, and then you are having the fencing, then the road. That's your land?
No, my lord. It's not my land, your lordship.
Whose land?
Your lordship, my land, his land is bifurcated by the
Beyond Bahini River, whose land it is?
government land. Beyond Bahini.
Government of Assam land.
Exactly, sir.
Now this land has kindly come to page 18.
Photograph.
Then how are you putting the fencing on government land?
No, lordship. Your lordship, kindly see, your lordship, Annex 3 of my affidavit, your lordship. Annex 3, page 15, your lordship. This is the minutes, your
Annex
lordship. This is the minutes.
Yes.
Clause 2,
Page.
page 15, your lordship, my affidavit, your lordship. Clause 2, your lordship. This is
Yeah.
the minutes.
The
The before
figures
taking
will
the
improve
lordship.
will consider so and so.
Sitting will be carried out only the defense land, your lordship. This is the respondent land, your lordship, and anti.
Understood. Kindly come to paragraph, photo at serial number 4. Page 18 of the writ petition.
Lordship.
You see the Bahini River,
Yes, yes,
then you have land,
yes,
then the fencing,
yes, lordship.
then the road.
Yes.
Whose land is in between the fencing and the bridge?
My lord, to clarify,
I don't.
Then how are you putting the fencing on the government land?
No, the fencing, that land has been acquired 1970. That
Acquired from where?
so kindly see the annexure 1, your lordship.
How does this
No,
court
this is
understand
this is the
annexure 1?
annexure, lordship. This is the extract of a military land register, your lordship. Kindly see annexure A, page 8, your lordship.
Yes, what is it?
Page 19. 425 acres of land has been acquired in 1970, your lordship. And that land, the fencing has been erected, your lordship.
Does your fencing extend, the land of the fencing extend to the Bahini River or not?
No, lordship.
What is
No,
the
lordship.
boundary of your?
Bahini River bifurcated the land, your lordship. Civilian and military and respondent land, your
Mr.
lordship.
Borbuzari kindly explain to him. I have not been able to convey it.
my lord, may kindly
You
peruse
see the river, the petitioner's house is there, then you have the river, then there is some land, and then the bridge, then the fencing.
Defense demarcation paper.
I'm only asking from Bahini River to the fencing, whose land it is?
Page 8 of my reply, my lord, I have annexed the map. Here is the affidavit in reply, my lord, page 8. Annexure A.
Yes.
This is the trace map, my lord.
Uh.
Notice will find this Bahini River have touched the road.
Uh.
This is the intersection, my lord. I believe this here.
Which place? Your area is which one?
My area is here, my lord. And this is what the place. This is the Bahini River, my lord.
So you are at that corner by which it touches the road.
Yes.
So you mean to say that if it is the road is obviously not the army road.
No.
So it has to be a government road.
Government.
So then how are you putting the fencing out there? How are you putting the fencing on that?
No, so we are not putting fencing on the government land, your lord.
You are. You see, he's saying
Your lordship,
as per
his-
annexure
his
affidavit.
schedule of land is touched the Bahini River, your lordship.
Huh?
His schedule of land, your lordship, southern part is touched his Bahini River. He is uncrossing Bahini River. Your lordship.
No, he's saying kindly come to annexure A. He says that corner annexure A of the affidavit in reply.
Lordship.
He's saying that corner which is touching.
Yeah.
The Bahini River touching the road is the place where the petitioner's house is, isn't it, Mr. Khan?
Yes.
That corner, it is your house?
Yes.
There is Dag number what?
That not that corner, my lord. This is road, my lord. This is the road. This is the Bahini River. My house is somewhere here. Somewhere not here, my lord. Just here, my lord. Here the Bahini
So
River.
this land which is there,
Yes.
that is not a government land. Whose land it is?
Where my house is there, my lord.
Beyond your house is the Bahini River.
Yes.
And whose land it is thereafter?
That is public road, my lord.
See, the public road is not there. Immediately after the Bahini River, there is some land. Whose land it is?
According to me, my lord, that my lord government authorities can verify, my lord. But according to me, this is the land belonging to the road itself. Road can be extended in future if required.
Are you saying
Little road-
that
little-
they have put the fencing on the government land?
Yes, my lord. They have their land here, my lord. So they started putting fencing here. This is their land, military land. This is military land. This is also military land. These all are military
So
land.
the putting of the fencing beyond the road is transgressing upon the government land.
Yes.
The government, I think you need to verify and come up with an affidavit. Because this is very relevant, what they are saying, because otherwise they will be putting the fencing on the government land.
And my lord, they have their own fencing, my lord. The military hospital's boundary wall, my lord, is
Now that is beyond the road.
yes, my that is their boundary.
So you are saying their land finishes with that military hospital.
yes. At
That
this
is
inter-
beyond the road.
at this intersection, my lord.
Beyond the
here-
road is their land,
Yes,
not the road,
not the road.
and beyond the, and towards your land.
Yes.
So they can't put the fencing.
Yes. At this
Now
point, they
that
cannot
makes
put, my
sense. Upon hearing the matter, it transpires that it is the allegation of the petitioner that the fencing which had been put by the respondent army authorities is on the government land. government of Assam land and not the land belonging to the army. It is the specific submission of the learned counsel for the petitioner that the land of the respondents starts beyond the road and not across the road, wherein the fencing have been erected. This aspect would require a clarification from the concerned circle officer, from a clarification from the concerned circle officer as to whether the fencing standing across the road erected by the army authorities is in the government land. This court, therefore, in the interest of justice, directs the circle officer Dispute Revenue Circle to file an affidavit, to submit a report as to whether the fencing erected by the army authorities is on the land of the army authorities or is upon the government land. This court also finds it relevant for the purpose of adjudication of the instant dispute that the Deputy Commissioner, Kamrup Metro, is required to make a party to the instant proceedings. Accordingly, this court impledes the Deputy Commissioner, Kamrup Metro, Guwahati, as the respondent number 5 to the writ petition. Further to that, this court, taking into account that there are bridges, temporary bridges being constructed over the Bahini River, on the basis of which the petitioner claims rights of ingress and egress, is of the opinion that the Guwahati Metropolitan Development Authority, GMD or GMC? The GMD, na? The Guwahati Metropolitan Development Authority requires to be made a party to the instant proceedings. Accordingly, the Guwahati Metropolitan Development Authority, represented by the Chief Executive Officer, having his office at Bhangagar, Guwahati 781005, is made the respondent number 6 to the instant writ petition. Mr. S. Burwa, as well as Mr. S. Bora, who represents the Deputy Commissioner, Kamrup Metro, as well as the GMD Authority, accepts notice on behalf of the newly implemented respondent number 5 and 6. A copy of the instant order. The petitioner is directed to furnish extra copies of the writ petition to the learned counsels of the respondent number, newly implemented respondent number 5 and 6. The petitioner is further directed to file a memo of parties before the registry of this court by tomorrow. The registry of this court, on filing of the said memo of parties and taking into account the order so passed herein, shall add the same in the cause title of the writ petition, as well as update the same in the CIS.
My lord, the army, my lord, they have
Mr. Khan, enough. We'll hear after that circle officer. A copy of the instant, this court further directs Mr. S. Purva to communicate to the Deputy Commissioner, Kamrup Metro, the order so passed hearing, thereby past hearing, thereby directing the respondent, the circle officer, Dispur Revenue Circle, to submit a report. Full stop. A copy of the instant order be also furnished to Mr. S. Purva for due compliance. List the matter again on 25th of September. We'll remove the entire fencing. The learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal. The interim order which was passed
25/5/2018.
on 25/5/2018 stands vacated.
One line, department will proceed with the election agreement.
The parties herein are left to take appropriate action in terms with the provisions of the Act of 2000.
18 and 19.
My lord, I'm awaiting the instructions, my lord, at all.
No, instructions are there, but the fact that by operation of law under 391 to 94,
Yes.
the amalgamation or the merger of the three states has happened. So that is by operation of law.
Yes,
Now, under such circumstances, you don't have any provisions which is there in the Bombay Stamp Act and anything to that effect. So under such circumstances, can you say that the mutation you would not be granted? The petition?
only difficult. my lord,
Which has
yes.
been, normally it is done in all cases.
Yes, yes. it is
And the notification which you are referring to, where there is a sale of a tea garden, the permission has to be taken from the state government,
yes, yes,
would be as regards the transfer by way of sale,
yes. That's
which is
yes.
however not applicable here.
No, therefore, my lord, with all humility, last date, my lord was pleased to pass an order on 21st, my lord. My lord's order contained two parts. First part, my lord, lordship has directed me, my lord, to obtain the instruction as to what is the office memorandum circular. My lord, to that extent, my lord, the pleadings itself goes to show that the department is relying on, my lord, this 26th March, which my lord has seen. So lordship will take a call on that. Secondly, my lord, what is being done? Pursuant to, my lord, the report that has been furnished from the office of the deputy commissioner, because it was at one point of time furnished to the department. It is a part of the my lord, petition. It is a admitted position, materials on record. Then it was, my lord, sent back that you have to comply with this 2001 notification and then revert back. That has also been done. Now the department is sitting over the matter. That is the allegation of the writ petition. To that extent, my lord, I am not receiving that instruction.
What instructions are required? The law takes its own course.
Yes, yes. Lordship is pleased to dispose it, my lord.
Why are
Other
there two
way-
writ petitions here?
Two gardens, Your Honor.
One is, my lord,
Two companies merged, Your Honor, with
Hmm?
the petitioner's company. Two different companies were merged with the petitioner's company.
Okay, what is 49? Which one is
49
4919 is what garden?
4919 in respect of the Jamira Tea Estate.
And the other one is?
Owned by the Jamira Tea Company Private Limited.
And the other is?
In other is Samsundar Tea Company Limited, owned in Nilmoni Tea Estate.
So what happened? There was a merger.
One is the passed by the Sanuru Court.
Is it a case of merger or demerger?
No,
amalgamation.
amalgamation.
Technically, it is amalgamation.
So that company was amalgamated.
Yes,
Merged.
That is what.
if my lord is
So
taking up the,
one case I'll dispose of it to Purivo. Because
if my lord is taking up, my lord, writ petition, my lord, 4934, the second one.
yes,
Second one, page 33.
what is that?
No, that is the scheme of
It's
amalgamation.
okay.
My lord, I am
Let us
going-
take 4919 first.
Yes, my lord.
The
49
instant writ petition has been filed seeking a writ in the nature of mandamus directing the respondent authorities to grant mutation in favor of the petitioner in respect of the land of Zamira Tea Estate, measuring 4026 bighas, 1 katha, 3 lechas, covered by various dags and patta number, situated at Moza, Zamira, under Dibrugarh West Revenue Circle in the district of Dibrugarh. Semicolon. A writ in the nature of mandamus directing the respondent number 7 not to cancel the tea board license of the petitioner. A writ in the nature of mandamus, semicolon, directing the respondent number 7 to pay the subsidy amount sanctioned in favor of the petitioner under the tea development and promotion scheme to the petitioner. Why are you adjusting both? Bringing those two causes of action as regards the respondent
What
tea
happened,
board.
Your Lordship, why we are before this only putting two aspects. One is non-granting of the end mutation, number one. And
That
meanwhile,
is
the
between
pendency of-
between you and the deputy commissioner's office.
Yes.
Why are you bringing the tea
No,
board
no,
out?
Your Lordship. During the pendency of my end mutation, Your Lordship, the tea board has put pressure on upon you to get the mutation certificate, otherwise everything will be held up.
What
So
did
that-
the tea board say?
We would say that within 6 months you have to produce the mutation certificate, otherwise your license will be not renewed, cancelled. Because Lordship is aware, without tea board license, I cannot run the TSP. That is the whole trouble, therefore we are report this immediately.
But wouldn't it be different?
Now we are only concerned with now that the grant of mutation your Lordship is decided. Otherwise we are not.
Mr. P. Dr. Dalani Senior Counsel upon instruction submits that if the relief as regards a direction for granting the mutation is granted, the petitioner is not insisting on the other two reliefs, which reliefs in the instant writ petition. The facts involved in the instant case is that pursuant to an scheme of arrangement under section 391 bracket 2 and 394 of the Companies Act 1956. The tea state and the tea company, namely Zamira Tea Company Limited, was amalgamated with the petitioner company. The said order of amalgamation was passed by the Calcutta High Court
4/5/2010.
on 4/5/2010.
Company. Effective date is 1st of April 2009. That is the appointed.
This court have also duly taken note of the order dated 4/5/2010 passed by the Calcutta High Court in company petition number 33/2010, whereby all properties, rights, and powers of Jamira Tea Company Limited including those specified in the first, second, and third parts of Schedule B, stood transferred with effect from the appointed date to the petitioner company. From the scheme of amalgamation, from the scheme of arrangement as enclosed, scheme of amalgamation as enclosed as Annex 4 to the writ petition. Various plots of land contained in various dag and pattas situated at Jamira Tea Estate, Dibrugarh, by operation of law and the order being passed by the Calcutta High Court, dated 4/7/2010, stood transferred in favor of the petitioner company. The records further show that the petitioner filed an application seeking mutation of the said lands on the basis of the order so passed by the Calcutta High Court, dated 4/5/2010. The said mutation case number that was registered, the said mutation application was registered as mutation case number 6/2012. However, the respondent authorities, on account of where is the document?
It's 73. 73 is the, my lord,
On account of a what is this? A communication dated 26/3/2001 have not granted the permission to the revenue authorities for granting the mutation in favor of the petitioner. It is under such circumstances that the petitioner has approached this court under Article 226 of the Constitution. Taking into account that the only reason why the petitioner's mutation have not been granted is the communication dated 26/3/2001. This court finds it relevant to take note of the said communication. It transpires from the said communication that the said communication was issued as it had come to the notice of the government that some tea gardens have been alienated by way of sale, oblique gift, etc., without following the rules stipulated by the government by letter dated 4/8/1995 and WT message dated 5/3/1997. It was further mentioned that in some cases, the Deputy Commissioner oblique the Subdivisional Officer Civil had reportedly allowed permission for transfer without referring the same to the government. It was mentioned that prior approval of the government would be mandatory in all cases, and cases where such alienation have taken place, the matter be referred to the government in the Revenue Department for examination and approval before allowing mutation.
Another quote.
It was further mentioned in the said communication that when an application is received for alienation, the Deputy Commissioner and the subdivisional officers are required to submit detailed file verification report covering inter alia the various points detailed therein. Full stop. Upon perusal of the said communication, it would be seen that it will only apply in cases of where there is a alienation to be carried out by way of sale, oblique gift, etc. However, when the Companies Act 1956 provides a mode by which companies can enter into a scheme of arrangement, and on the basis of such scheme of arrangement as stipulated in section 391 to 394, read with the Company Code Rules 19. What is the Company Code Rules? You do?
7, I've forgotten my.
Read with the Company Code Rules. It is the opinion of this court that the said scheme, that the said communication dated 26/3/2021 shall not come in the way in granting the mutation in favor of the petitioners herein, who by operation of law as well as by virtue of the order passed by the High Court of Calcutta, Calcutta High Court, dated 4/10/2010, 4/5/2010, the Jamira Tea Company Limited stood amalgamated with the petitioner company, along with all its assets and liabilities. Considering the above, this court therefore directs the respondent authorities, more particularly the Deputy Commissioner, District Commissioner,
My lord will direct, my lord, the department as well as the district commissioner, both, my lord.
what is the department going to do? No business of the department. If this doesn't come, then how does the department have any problem? I will only, can I direct when if I say that this notification is not level?
Yes,
I can't direct. Yeah.
yes. Otherwise, my lord, mutating authority is the district, as per the land revenue regulation, yes.
and accordingly directs the district commissioner, Dibrugarh,
Dibrugarh.
to grant the mutation in favor of the petitioners. In favor of the petitioner. In respect to the land which stood transferred by operation of the scheme of amalgamation, which was approved by the Calcutta High Court by order dated 4/5/2010. The same be done within a period of 3 months from the date of a certified copy of this order is served upon the district commissioner, Dibrugarh. This court further finds it relevant to take note of a submission being made by Mr. B. Dutta, the learned senior counsel, to the effect that a direction may also be given to the revenue authority. Full stop. It is the opinion of this court that when the notification, the communication dated 26/3/2001 is not applicable and would not come in the way of granting mutation in favor of the petitioner for the reasons above mentioned, no directions is required to the revenue department of the government of Assam. With the above, the instant petition stands disposed. Itu henekwa. Date to bodli jabo.
And that
Garden is Nilmoni Tea Estate and the company name is Samsundar Tea Company. And grand mutation number is 60.
only that company code rules 1959. I'm sorry, my lord. I'm obliged.
I had one when I was a lawyer, this company code rules 1959. You see, these stipulates that the first meeting, first you file a company application.
Yes.
The company application, the moment you file, what is required is you take a permission from the judge in his chambers to hold the meeting of the shareholder. Now, what happened when I was a lawyer, there was a matter pertaining to demerger for Tea State. What happens, the demerger is, these are mergers, this is simple. A Tea State is demerged out from a company and brought to another company. And from that company, it is merged to another. So this is how it works. So I took the permission out there from the judge in the chamber that this way. He said, okay, no problem. Give me, you have to have 14 clear days notice. The 14 clear days notice was given. By the time the judge was also to the effect that he signed it, but I could not get the copy for which the meeting can't be held. So I filed an application for extension. So the judge said that I made every effort to sign it so that there is no problem of the 14 days clear days notice. I said that maybe, but the fact that without your file reaching that court, taking a certified copy is useless. That file has to reach the particular office, and you have that office, the company section has to then vet it through the registry. Then only that notification can be published.
Yeah.
And that file did not go. So I got the extension.
Those 1959 rules are very minor strict to censor. They're very case of holding subsidiary, all these things will come. I'm obliged.
56. Idiki. Oh yes.
has been filed for withdrawal of my lord.
But your speaking order has been passed, your
No.
lord.
এইখন দিব, huh? The instant interlocutory application has been filed seeking withdrawal of the review petition in view of the order dated (16/8/2023) passed by the Secretary to the Government of Assam Department of School Education, whereby the judgment of this court dated 21/7/2022 passed in WPC number 6721/2018, linked with WPC number 4733/2018, has been already complied with. So accordingly, the instant application seeking withdrawal of the review application is allowed. Review petition in view of the order passed in IAC number 2494/2023, the review petition stands rejected.
Obliged, my lord.
27.
Wait, your lordship.
Yes.
Before my learned senior starts, I have a small prayer, my lord. Mr. B. Chaudhary appears for this matter. He was very much here, but due to some personal medical emergency, he have to leave the court early, my lord. He have to leave the court early, my lord. Mr. B. Chaudhary, standing counsel.
This matter pertains to what?
Pertains to
Notice.
No, my lord, in
Mr. Bhatti, what happened to that case?
this
One matter was there which I have to regard the notice.
notice listed that has not been listed.
No, I fixed it these days somewhere.
Yes. Most
I remember that case
Yes.
pertaining to the notice was not properly issued or something.
Yes.
They did not mention it.
Yes.
Ah,
GST Act.
you remember that?
Yes, I did. It is 6th on 14th September.
Oh,
My
the
lord,
learned counsel appearing on behalf of it has been submitted on behalf of Mr. P. Chaudhary, the learned counsel appearing on behalf of the Finance and Taxation Department, that some more time is required for filing the affidavit in opposition. It reveals from the record that on 1/2/2023, this court had granted 2 weeks' time to the Finance and Taxation Department to file the affidavit in opposition. Taking into account the above, lists the matter on 6th of October 2023. It is made clear that if the affidavit opposition is not filed by 25th of September 2023, this court by 29th of September 2023, this court shall dispose of take up for disposal the instant writ petition on the basis of the pleadings available on record.
Highly obliged.
Yes,
20th, my lord, instructions have been received. I'll require some time to file affidavit.
you want to file affidavit?
Yes, right.
What is that matter?
This is imposition of VAT duty on excise goods.
that is saleable and unsaleable quantity of liquor, my lord.
Huh? Oh, that.
Yes. The lordship earlier fixed the matter, my lord.
There's another matter you have
Yes,
filed.
yes.
Where is it?
But it is fixed on, my lord, September, my lord, 11th. Rupapur.
Yes, madam. That affidavit will cover. So we are preparing this also. We need some.
So you file it by
Yes,
September.
yes.
Will you have it there on
Yes,
September
yes,
11th?
it will be filed. Well.
Because that the issue is as regards as per 36 2015 or 16.
16.
16. at that point of time, there were certain unsaleable
My lord,
goods.
my lord.
The joint inspection was carried out and unsellable and saleable. They have imposed tax on unsellable also. That is the
A tax,
VAT.
but
When?
have you made the finance party?
No matter.
If you are not making, the loss is to them. The problem what has happened is they have made a recommendation. The Commission of Excise has made a recommendation
Yes.
for giving you the benefit.
Yes.
The government says that nothing, the government says that during this COVID time, we are not in a position to grant any exemption. So without making the finance a party, how can you do that?
I'll make that.
List the matter on 11th September 2023 along with WPC number. Because without the finance, this can't be disposed of.
Because it was joint and it was on their recommendation. Yeah,
Because you made a recommendation.
Yes.
The Commissioner of Excise.
Yes.
They kindly don't take it.
Don't.
But the government made it very clear that no, we can't leave it. It's a huge amount.
finance is insisting, man.
I have.
What is the repetition number?
I'll give the number.
Is the matter on, so you have that matter number?
As of now, I don't.
Okay, list the matter on 11/9/2023.
Publish.
In the meantime, the respondent, Excise Department could be at liberty to shall file the affidavit.
Publish.
29 and 30.
30, I think, Lordship, my lord.
Which one?
29 and 30, my lord.
Oh, no. Before any other.
One.
Affidavit,
Lordship, short accommodation may be given.
we have it on 13th. File your affidavit without fail, or we are going to dismiss.
Not interestingly, on 21st, they file a press application.
Let them file the affidavit. Once they file the affidavit, then we'll take a call. But if you don't file the affidavit, we are going to dismiss it, telling you, huh? List this court by an order dated 21/8/2023 had directed the petitioner to file an additional affidavit by 28/8/2023, bringing on record those received copies of the applications so submitted on 2/2/2021 before the Commissioner GST and Central Excise for the periods from 2008-21, 8-2009, 2009-2010, 2010-2011, and for the period from 2013 to 2014. This court had directed the filing of the said additional affidavit, taking into account the specific instruction and submission and the specific submission made by Mr. S.C. Kyle, the learned counsel for the GST, upon instructions that there was no representation as such was filed on 2/2/2021. This court cannot also be unmindful of the fact that there is an interim order operating in favor of the petitioner on the basis that an application, representations was filed on 2/2/2021. Accordingly, this court makes it clear, grants a further adjournment, a final adjournment for the purpose of filing the additional affidavit, which has to be filed by 11th of September 2023. So it is made clear that if the said additional affidavit is not filed as stated herein above, as stipulated herein above, it shall be presumed that the petitioner did not submit any representation. Full stop. list the matter on 13th of September 2000.
Much.
Yeah, I got it. On 20 along with 32. Yes.
Next, Your Lordship, my lord, matter pertains to onboard catering in the railway. My lord.
Hmm. Where is the railway?
It is, my lord, it is in the, we are, that in the COVID period, my lord, due to the, that, all of the, that footfall was low, almost nil, my lord, many trains were cancelled. My lord, we are basically on two issues. Number one, my lord, that there was a
Okay, we'll have it on. So you are enjoying an interim order.
interim, no, my lord.
Huh?
No interim. Outcome of the read. Anyway, my lord, lordship may fix up the time.
Oh, this is IRTC.
IRCT.
Railways is also there.
Railways, we have made as a.
Railways and IRTC will be there.
IRCTC is the main. My lord, we will, we have,
Taking into account that the railways as well as the Indian Railway Catering and Tourism Corporation Limited are not represented, nor they have filed, are not represented. This court fixes this matter again on 25th of September 2023. The petitioner in the meantime shall be at liberty to file an affidavit in reply to the affidavit in opposition filed by the respondent number 3 to 6.
I'm to clear that.
35. Yes.
Here, my lord, I am aggrieved by the action of the North Kasar Hills Autonomous Council for acquisition our land,
Hmm?
our village for compensatory afforestation in connection with the 120 megawatt lower Kopili hydroelectric project. So we are the residents of a village called Nabdi Daulagoko, which is in Dima Hasao Autonomous Council, my lord. And our land was acquired by the impugn.
The land has been already taken.
Not, my lord. There is a status quo order. They have taken a move, my lord, to acquire our land, 86.3 hectare of land, my lord.
That has been stayed.
Yes, my lord. There is a status quo order, my lord.
And if it is stayed, it has been stayed since when?
During
2021.
21, my lord.
Until now it is stayed. So they have not been able to work anything.
No, my lord. In fact, during
Why haven't you filed affidavit?
they have not filed any affidavit.
We have not received instruction, not a 2 weeks,
You are not serious, that means.
not a bit serious.
How, if you are serious, then why you are not filing an affidavit?
The status quo order was given, my lord, on the basis of a submission made by the Council for the North Kasar Autonomous Council.
However, till then
There-
it is
there was a-
provided that the status quo as regards the petitioner's village for the purpose of compensatory effort in terms with the communication shall be maintained.
There was a
Not-
negotiation between the villagers and the
2 weeks time may be granted.
it is their statement that there was a negotiation between the parties, my lord. That is why on that count, my lord, status quo order was given during that time. And in fact, I have also no contact with my client during this period, my lord. Since it was listed first time after the motion, my lord.
This petition, this court, by an order dated 1/6/2021, had passed the interim order, thereby directing maintenance of status quo as regards the petitioner's village for the purpose of compensatory afforestation in terms with the communication dated 1/6/2019. Full stop. The NC Hills as well as the Forest Department have duly received the notices, but no affidavit has been filed. in spite of an interim order operating. Under such circumstances, now, this court further finds it relevant to observe from a perusal of the writ petition that various work orders have also been issued, and the interim order may or may not have may affect such work orders, such may affect such
Well, these-
construction works, which may result in escalation of the prices.
well, this scope order relates to, my lord,
However, the Forest Department as well as the NC Hills Autonomous Council have kept silence over the same in spite of more than a passage of 2 years. This court grants a final opportunity to both the Forest Department as well as the NC Hills to file their affidavit in opposition by 25th of September 2023. Full stop. It is made clear that if no affidavit in opposition is filed, this court shall take up the matter for final disposal on 4/10/2023. Interim order passed earlier shall continue till.
well, my lord, this scope order relates to the construction work carried down in our village, my lord, not regarding their afforestation work, my lord.
That is why I use the word may.
Oblige, lord, oblige.
Section 37.
Yes, what are these matters?
Is related to the settlement by Gumti Milo.
Hmm?
In a bit, the Tharupetia market.
Hmm.
A plot of land along with a construction thereon was allotted to the petitioner in this case. And in the meantime, after some years, Milord, his papers are there, Milord, which will show that settlements are in their favor.
What is the impugn order?
Impugn order here is, Milord,
Page 18-2. Which one? Where's the impugn order? 18/2/2021. Where is it?
my lord.
Page 18, ma'am.
Huh?
Page 18.
18.
Yes.
Huh? What 18?
19.
18/19 is not that impugn order. 18/2, page 19. Okay, got it. In the petition of Osim Roy paying for allotment of Gumti number in month, the Karupetia board as they are protesting in the petition. We make that from the above. So they
Against,
have decided to give it to Osim Roy, Uttam Saha and Baba. And you are against that.
5/12/2002 order, Milord. Against that, Milord, we came to the High Court. High Court, initially, it was against us. Then we went in appeal. In appeal, Milord, that is referred to, appeal passed an order remanding back the matter to the municipal board to reconsider the whole thing.
did not find any merit in this objection with the observation, and we have heard the learned counsel and none appears for the Crown Committee in question privilege. Learned counsel for the appearance of this question and counsel with the intent of complete such ethic and demand them to take it.
Then I may refer to the appellate order, my lord, that you will find that annexure B page 16.
I read it.
Appellate,
You are referring to page 17.
my lord, my lord.
That is the direction.
That was the direction. And after that, my lord, annexure C, page 18 order was passed by the municipal board.
Hmm.
Where
Page-
your lordship will see this
Understand?
information on
Yeah.
understand
Mm.
authority board is meeting held on demand done through the directions of the Honorable Guwahati High Court passed in April. And in this connection, to resolve the dispute of Gumsi number 86, Karupetia Daily Bazaar under Karupetia Town Committee, decided decided by resolution number 6 to vacate the present occupation of you to these persons below, to these three persons.
Mm.
Same.
Then,
Then while this matter was
and
there,
then
below,
they filed this other writ petition.
yes,
My
against
lord.
this, my lord, against this, they filed the other writ petition.
And they just stay.
There is a stay. And while the matter is there, my lord, while matter was pending before the Honorable Court, my lord, they passed the 18 order.
But was there any bar to pass the 18 order? That's in compliance with the division bench order.
No, after complying with the division bench order, they passed an order. Board. By passing that order, my lord, executive authority has, executive officer has passed. Board has passed, my lord, your lordship will see. Board in council.
So you mean to say that after the division bench passed an order,
Hmm.
they passed another order
My
that
lord,
is on 28 2013
yes,
against them.
yes,
For that, they have filed a writ petition.
my lord,
The writ petition is pending.
pending.
Then there is only a stay. Then they have exercise again to give it to them.
Yes,
That's your case.
your honor.
My lord,
Yes.
what happened, my lord? The petitioner, my lord, this said, my lord, he was allotted in my lord 1993. What he did, my lord, he sublet to my lord 3 persons.
Oh,
my lord.
Mr.
that-
Chauhan, Mr. Chauhan, we are not on all those aspects of the matter. I am only on one thing.
Because my lord.
I'm only
no-
on one thing.
Nobody, my lord, paying the rent, my lord, my lord, town committee, my lord.
No,
working, my
whatever may be, you see, the division bench had directed them to dispose of the matter
Right.
after hearing both the sides. After that, they have taken a decision and asked you to vacate.
Right.
An order has been passed by
Right.
them,
Yeah.
thereby complying with the division bench order, rightly or wrongly,
Right.
whatever. Which you have challenged in this writ petition in 2013.
My lord, my learned friend, my lord. I am
Yes.
for that town committee, my lord.
Okay, okay.
Municipal
Now,
court.
which, let us know, they have, which he has challenged
Challenged
it
it before
in
the
this
court.
writ petition. There is a stay to that order.
Status quo order.
Yes, whatever may be.
The order had not been set aside.
Yes.
That order has not been set aside. So that order remains. So you have already exercised the division bench order. Rightly, wrongly, you have passed an order.
Right.
Thereby wanting to throw Mr. client, for which he has filed only a status quo as regards that possession will be there.
Hmm.
And he has been enjoying for the last 10 years
10
by
years.
way of this insanity.
And-
Thereupon, you passed an order in 2021. Must be fed up with the pendency of the matter before this court and gave it to them. Isn't it?
My lord,
Since 1996, my lord, town municipal board, my lord, losing my lord the revenue, my lord. Nobody is paying.
I understand you are losing the revenue because both sides are not paying.
Not paying.
So the best option is to set aside that order and this order,
Well,
and then ask you to decide and decide it, and within 30 days
Well,
and
yes.
throw them out if they have not paid
yes,
anything.
my lord.
And you may also give you also the liberty that during this period, when they were in occupation,
My lord.
to realize the said amount from them. You can realize the amount from
Yes,
them.
my lord. Both side, my lord, that person, my lord, the petitioner of this case, my lord, sublet, and there, my lord, trespasser. Nobody, my lord, ever paid.
No, let everything, they may be trespasser, but then you have given it to them.
Yes, my lord, they are in possession.
You have given to them, you are saying him to be a trespasser. During, when you were thinking to throw them out, the writ petition was filed. You wanted to give it to him.
My lord, both the order may go, my lord, express petition, this is the best option.
Court are disposed of.
My lord.
I'll pass the order.
My lord.
The order will be like this, both are set aside, directing the municipal board to decide, reconsider afresh, taking into account, and the municipal board shall also be at liberty to realize the amounts during the period when the writ petition has been pending, if these people have not made any payment.
Within a period of 6 weeks.
My
Huh?
humble prayer, my
Within
lord,
a period of 6 weeks.
my humble prayer, my lord, that once they,
Who is going to run now?
I am running, my lord,
No,
5,
no,
6, 7. My simple prayer,
1
my lord,
month. Why you need 6 months?
Not 6 months, 6 weeks.
1 month.
Okay.
1 month you decide,
Yes.
and you recover, you have given the liberty to recover from these people.
Right.
And that shall be also taken as a consideration for the purpose of granting allotment.
my lord,
Okay.
my simple prayer, my lord, that High Court judgment, my lord, that the civil suit, my lord, for that because they are
No,
subletting, my
Mr.
lord,
Counsel,
they are
kindly
based on-
listen one thing. You are in allotment. You say that you have an allotment.
I have done that.
No, you
Which is
say
not
you have an allotment.
No, not.
You don't have an allotment.
No, I allowed to continue, but no formal allotment.
Not by GMC. my
Under
lord.
what provision you are in occupation of that land? Or of that Ghumti?
Lord.
Under what law? On what basis? You have to have a right.
But there was earlier order, my lord.
No, orders can't be there. There has to be an order passed by them. Have they allotted it to you?
Now, my only prayer, my lord, that they all the High Court, all the case of civil suit, my lord, that may consider while, my lord.
No, I'm nothing to do with that. Only simple question is under what basis you are there in occupation?
My lord, that is,
Under what basis? Show me the basis on which you are in
because
occupation.
civil suit, my lord, they failed to, my lord, evict us. And against which, my lord, that the revision came, my lord. Revision also, my lord, dismissed. That therefore, my lord, we were in continuous possession.
As what? Trespasser.
My lord, this petitioner filed a
Because
suit, my
what?
lord, for realization of rent and for ejectment, my lord. It was initially decreed. Then, my lord, they prefer, my lord, a title appeal. This was, my lord, reversed. The revision petition in the High Court, revision petition dismissed. Ultimately, this petitioner lost.
And
This-
So you granted the allotment to them,
Yes,
I am
initially,
I
1983.
purchased the bill and
And he subletted them.
and he subletted to them.
Yes,
my lord.
This is the case.
But who, and who is the owner?
And the
We are
authority-
concerned about the Ghumti.
Yes.
Authority,
And the
the owner of
Ghumti
the
is given by whom?
My lord, given by my lord, earlier town committee. My lord.
Midtown
The
committee.
land
And
was allotted
Ghumti
to me.
belongs to whom?
Belongs to Kharpetia town
Kharpetia
committee, now
town.
Kharpetia town municipal board.
municipal-
Ghumti belongs to the Kharbutia town committee.
Yes, my lord.
Yes, my-
So there has to be an allotment being made.
Yes.
Yes, my lord.
allotment
They
was
decided to
initially
allot in
given to
favor of
them
us
in
instead of
1983.
Yes,
They
in
sublet my
case,
lord. The
Annex A,
petitioner sublet them.
So
And there
allotment
was-
has been made in favor of him,
Yes, in 1983.
and he subletted it to him.
Yes, my-
Now he wanted to evict him.
he wanted my
He
lord
has not
paid.
been able to evict him,
Not paid.
and that matter went to wherever it is. That is another aspect.
Yes.
But the allotment has to be made by you.
Right, my-
So you cancel as of now. Then this needs to be stopped. It's a
my-
very serious thing. He also can't run.
Well,
What business does he have to run?
About the actual possessor that.
For that, Milord, for that reason, Milord, the page, your lordship has seen the order.
17/8/2013.
Yes, Milord, that order was passed by the board.
They don't have any authority.
18 order.
And what authority? They don't have an authority from you.
No.
And do you permit allotment, subletting?
No, not approved, nothing, my lord. My lord, secret. There's the secret contact.
Then in that regard, I will do one thing. I won't pass the order now. I will pass the order on 7th. 7th, I will pass the order in your presence.
Only 7 and
Seven, I am
they have
taking
not done
it.
any other date except
7th.
8 or my lord,
You
nine,
no,
my lord,
need
seven.
not. I am only passing the order in your presence. That's all. In your front. I am not going to pass the order inside. I want to pass the order in your presence. Because today I am rising at 3:15.
Right.
So list the matter on 7th for final disposal. Yet, otherwise I will have because this is not a case where I will remand it back. No. That thing has to be set aside. They have no business to be there.
Yeah.
And you take a
Policy
call
that
on
already
them
there,
to
Milord.
whether the allotment
after
if they have
cancellation-
violated the settlement.
After their cancellation, that committee decided to allot in favor of us and because we are actual possessor.
That has to be also set aside. How can the committee think of allotting it to you when the matter was pending?
Yes,
How can the committee think of giving it to you? The committee will decide.
August 13
But
order
that
was
has to be,
already
your
there.
thing has to be cancelled. As of now, you have to be removed, both of you. And the committee, let the committee decide.
Committee will decide. Whether-
So that order I'll pass in your presence on 7th.
38.
Yes.
Your lordship, after doing some research, your lordship, I found that our case is not covered by the notification dated 15/11/2014.
Public place.
Your lordship.
Have you filed the affidavit?
No, my lord, I need some further 10 days time, my lord. Instructions are awaited, my lord. Kindly 10 days time, my lord.
Mr. A. Bhattacharjee 6, an accommodation of 10 days for filing the affidavit in terms of the order dated 14/8/2023. List the matter again on 25th of September 2023. The affidavit be filed by 21st of September.
39.
Obliged.
Yes,
In this case, my lord, as directed by this honorable, although affidavit could not be filed, instruction we have received, my lord. As per the instruction, it's a fact, my lord, over the existing embankment, it was constructed, my lord. No new embankment was according to. And in fact, the original one is
yes, what is your stand? Reconstructed embankment is there in so and so. Embankment goes upon the land bearing tag number, Iman and periodic Patha number. Tag number 25. No details are available in the land acquisition with respect to the first contract of the land is both of the acquiring land. Now, here the petitioner is claiming in respect of doc number 28, 193, 14, 34,
yes.
300, 519, 6, 203, 154. Have you acquired any Is the embankment going through there?
My lord, going through only 25 and 76.
20, dark number 25 or periodic patta number 7.
Yes, sir.
There is
25,
one.
yes,
Only one dark,
yes.
not in regard to
Yes.
others.
This is the
You
instruction
file
received
your
from the,
affidavit
my lord, yes.
because this is because my order was specific to file an affidavit stating as to whether in this plot of land mentioned in paragraph 2 of the writ petition, is there in any embankment? Because her case is that there is an embankment created, not left, wherein it was stated that the land negotiation was not required in the left bank, as it was the scheme executed for raising and strengthening of work over the existing embankment.
Yes.
And as such, the land acquisition under Daga does not arise. This court directs the EA to clarify the state by way of an affidavit. So in terms with this, you file an affidavit. Because if I remember that day, Mr. Goswami, you made a submission that the question of acquisition did not arise
Right.
because on the left bank, there was nothing out there.
Yes.
And
It
as
was- it
such,
was-
you have
it was-
only
it was an
strengthened.
Existing embankment, my lord. And to raise that, my lord, the new scheme was taken up.
Today, Mr. B. Goswami, the learned additional advocate general, have placed on record some instructions. Footstop. The said instruction, however, is not clear as regards the query so made and the direction so made in the order dated 7/8/2023. Footstop. This court fixes the matter again on 27th of September 2023. Footstop. The Deputy Commissioner, Morigaon, is directed to file the affidavit as directed in the order dated 7/8/2023. The said affidavit be filed by 22nd of September.
All right.
57 to grade you. Yes. Deficit court fee.
No, that has been submitted, madam. As per my instruction, madam. I am appearing on behalf of Mr. S.K. Theory, madam. He is not here.
Good. Deficit court fee paid. Then now,
Lord, the grievance of the petitioners are that their applications for allotment of land, my lord, that were not considered by the revenue department.
Hmm?
The applications for allotment of land, my lord, were not considered.
how much land?
Lord, it's about 14 bighas of land, my lord. They were residing there since 1988, my lord.
You have filed an application for allotment.
Yes.
When?
Since first application was filed in the year 1988, my lord. Thereafter, last one was filed in the year 2016, my lord.
What is the present status as per you? Or you don't know anything? Or is this a fishing and roving inquiry?
Lordship, on the last occasion, Lordship found out that the court fees hasn't been paid properly.
He has paid. Now tell me. That is between me and the court. Him and the court. Now what have you done to his application? Mr. Counsel, the problem which arises is you should not file so many persons with so many petitions because everybody's case is different.
That is true, but
Show me that you have filed all the applications, that you have submitted application for everybody. Show me. Show me from the petition
those are not there, my lord.
Huh?
All the
No,
applications are
show
not
me.
there.
that everybody filed an application. And you know the application can't be filed in this manner. The application has to be filed in a particular format. You can't file it in this manner. We are residing in so and so grazing reserve. Oh. We want a grazing reserve.
Yes, my lord.
Oh, we dismiss it on that ground only. Matter in. The instant writ petition has been filed. Where is the judgment? Jakpal Singh. Jakpal Singh, what's the citation? The instant writ petition has been filed seeking a direction from this court upon the respondent authorities to allot the land on the basis of their application so filed in the year 1988 to the Deputy Commissioner, Nagaon. The said application is enclosed as Annexure 1 to the writ petition. From a perusal of the said application, it reveals that the petitioners are seeking allotment in respect to a plot of land, in respect to the plots of land
I think have within para 9.
which are located, now which is reserved, which are village grazing reserves under Botodrova Moja. Full stop. Taking into account the judgment of the Supreme Court in the case of Jakpal Singh versus so-and-so, reported in so-and-so, there can be no allotment or settlement in respect to community lands which are village reserve, village grazing VGR, village grazing reserves. Under such circumstances, the question of directing the respondent authorities to allot settlement in respect to the village High Dubi grazing reserve under Botodrova Moja cannot be passed by this court. Accordingly, the instant writ petition stands dismissed. Full stop. However, this court observes that if the petitioner, this court observes that the petitioners who claim to be landless people would be at liberty to file appropriate application before the concerned authority in terms with the Assam Land Policy 2019 seeking settlement. Yes, any urgent matters? You are cricketers. I have to rise at 3:15 today.
I know 40 orders.
Orders are good. These orders are there, no time. Contempt case, yes, what is there?
Yes, okay, Mayor, in this case, some time is required, Lordship, as
For what?
verbal instruction from the Revenue Department, Lordship, for approval of Lordship plan. Even to the Lordship.
How much time?
4 weeks, Lordship.
No.
No, Lordship, in this case.
2016 contempt matters, does it take so many years?
No, Lordship, in this case, a cabinet decision is also required, Lordship, as per instruction of the Revenue Department, Lordship, for allotment of land, Lordship, all.
No, here we are concerned with 1 bigha of land.
Yes.
Are you saying that for granting 1 bigha of land, the cabinet decision is
Yes,
required?
as per verbal instruction of the Revenue Department, Lordship.
Huh?
Yes, sir.
What is this? It can't be. Are you saying that cabinet decision, or are we to understand that day the chief minister said that we are having 100 cabinet decision meeting? It is on because of all these things that the cabinet now also decides of land allotment.
Yes. Then after 2 weeks, Lordship, then written instruction will come then.
Cabinet decision land allotment.
Yes.
Don't make this type of submissions. Let's the matter again on. Miss Didi Borman, the learned additional senior government advocate, submits that she is yet to receive the instruction as sought for by the order dated 16/8/2023 and seeks for an accommodation for 2 weeks. Lists the matter again on 15th of September 2023, on which date the learned council shall ensure that the instructions are received. It is made clear that this is a contempt proceedings of the year 2016 and already 8 years, no, 7 years have passed by.
Petitioner is also Lordship.
Not necessary petitioner, we don't require. This is contempt is between you and me.
For so long time, Lordship.
It is between you and me. We don't require a petitioner for contempt.
Of like
42.
them contractual dues, we don't require petitioners. Yes, madam.
On the other last occasion, the petitioner wanted to find out whether what is the ground reality now. So the petitioner apparently is
Mr.
not.
Sarkar, Learned Council shall obtain as regards the present status of the alleged water drain stated in para 15 of the contempt petition. Now, as per you, what is it?
As per me, there's nothing. There was this garden drain, which I was clearing up. And he
Let's see the
claimed that
direction passed by the court. Contempt against which order?
My lord, there are two orders.
Drawing of
One
contempt.
filed by
Yes,
the
Mr.
executive.
Sikdar, which order?
My lord, Annexer C.
Annexer, page,
My lord, page.
interim order.
My
What
lord,
happened to the writ petition?
my lord, there is a previous petition.
Until further order status quo with regard to the land mentioned and
Annexer
letter
B
dated
also.
so and so as referred, which was continued till the decision is taken by the deputy
Yes.
commissioner, Kacha shall be maintained.
The decision is to be taken by the,
Now you are saying that the status quo has been violated.
my lord, violated there, my lord, the DC has also not taken any decision. my lord. That is my view.
these
That is a, no. Is there a direction to the DC to do it?
My lord, there is a previous order, my lord, for taking decision.
We are concerned with contempt of what?
Yes, my lord, we are facing, my lord, they are forcefully
Court,
occupying and trying to evict us.
you are concerned, we are concerned with order of 6/4/2018
Yes, my lord.
Okay.
That status quo is to be maintained, that order is going to be violated.
and the earlier order of 2013.
Right.
Which order?
My lord, 2013 order,
You have not enclosed.
my lord, enclosed, my lord,
Where?
at Annexer A, my lord. WBC number 856, 2013.
In the meantime, status quo in respect to the land lines mentioned in the letter dated so and so shall be maintained. Now, what is the status quo?
My lord, we are there, but we are under, my lord, we are under it. There is an attempt to evict us. my lord. And
They have not evicted you.
my lord, not yet evicted, but they are making an arrangement,
Oh,
making attempt.
There's an order there. They are not going. Are you going to evict?
no lordship, the DC has to demarcate the land.
You are not going to evict.
No, obviously not.
My lord,
The deputy commissioner has to do it, not me.
Deputy Commissioner,
my
are you
lord,
evicting?
my lord, the respondent, my lord, they are coming with a huge number of laborers and they have enclosed, my lord. And they have.
That's not
actually
correct,
evicted us, my
lordship. I was, they only
They
alleged
have,
about.
they had some, my lord, drain, my lord.
Mr. Sikdar, what type of petition is this? Whom have you made parties? Is this a writ petition?
My lord.
Huh?
My lord,
Are you making state of Assam a party in a contempt? Is it a contempt or writ? Contempt. The Commissioner and Secretary to the Government of Assam Revenue and Disaster Management as a party. Commissioner Hills Division, Principal Secretary to the government. And this court has issued notice. You are so lucky enough.
my lord, I am not the original lawyer, my lord. That is the problem, my lord.
Huh?
I am been asked to appear in the case. I have filed, followed my yesterday.
The learned, this court had inquired with the Learned Counsel appearing on behalf of the petitioner as to what is the violation of the orders which have been alleged in the instant contempt proceedings. The Learned Counsel submits that there are orders of status quo to be maintained. Status quo. There's an order, there are orders passed by this court, 2 orders passed by this court, dated
My lord, one is,
22/2/2013, as well as 6/4/2018, directing the parties to maintain status quo. Full stop. This court further inquired with the Learned Counsel as to what is the meaning of the status quo in the said orders. It was submitted by the Mr. A.R. Sikdar, the Learned Counsel, that the there was an attempt being made by the respondent authorities to evict the petitions. And as such, in spite of the order of status quo, Ms. M. Hazarika appearing on behalf of the respondent number 10 and 11.
What was the contemner? I am for the contemner. That's Amardeep Chaudhary.
You are not.
Yes.
Appearing on behalf of
Next
respondent,
page.
the sole respondent
Yes, Lord.
submits that the petitioner, that the contemner do not intend to violate the order so passed by this court. And there is also an taking into account this, nothing survives in the instant petition for which the contempt proceeding can flow. Be that as it may, the respondents in the writ petitions are pending. Writ petition,
There are a lot of literature, not just one.
no other writ petition pending.
Some more are pending, Doctor.
Give the list. We'll take it up and finish it up.
Yes, Doctor.
Yes,
Relating to this
You give
matter.
it to him.
I'll give it.
We'll ask the registry to list and finish. Yeah. This court further observes that the closing of the contempt proceedings should not be understood that the respondent, this court further makes it clear that till the orders dated so and so and so and so continue to remain in existence, the parties shall be bound by the said orders. Yes.
47, my lord, I is for amending the application, the writ petition. Lord,
Amending the writ petition. What is there?
item 47. Where is the I?
Somebody has filed objection.
My lord, we have filed a objection.
What objection is there?
Thereby, my lord, they are going to challenge our sale deed, my lord. I am the respondent number 4.
Telling the sale deed in a writ petition.
My lord.
Fantastic.
Allotment order was there.
Okay. एक इधर डेट किधर दी थी वो बाकी किधर
Lordship in item number 51 to 55, there is an interim order.